Sure. Anytime. I love your dances. My darling girl. Then show to Nico when he comes back, okay? Are you okay, Danny?
Now I'm able to breathe.
Good. See, this drop is not a problem at all.
ಮೇಡಮ್ ಆಡಿಯೋ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್, ಲೈವ್ ಇದೆ, ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆ ಪೋರ್ಟಲ್ 2 ಇಂದ.
Because nowadays use platforms is available and this branding is not possible. Branding is not Yes, Mr. Amresh.
Minutes, there is one writ appeal minutes pending for admission for the past 6 months. Minutes, this is between two PSUs, BHEL and BSNL. There was a dispute and the permanent ministry of arbitration has
But what is the petition?
petition, writ appeal, my lord.
Which year?
This year, 2024.
It will be court one.
24.
23, ma'am, sorry.
Sure,
Sure.
sure.
There it is, attendant. Admission.
Show us, what is the urgency?
Urgency that means the award passed by the permanent ministry of arbitration. Yes, permanent ministry of arbitration took over the jurisdiction on its own, even though there is no arbitration clause existing in the agreement.
It can wait vacation, na?
Award passed, then we filed the writ petition. There was a stay.
You
And
mention it after vacation, after the holidays, that would be
Yes.
better.
yes, sir.
Okay,
Yes, I am getting.
thank you. Just call the minutes.
With the lordship's
My
leave,
lord.
mention a matter, my lord. My lord, a batch of matters regarding 371J was listed before your lordships on Monday. The lordships have adjourned it to 11th of November. My lord, I have thereafter moved a memo for clarification, an IA for clarification, my lord. My only request is, can it be listed before the vacation? The urgency is the counseling is to be conducted sometime next week.
Which matter, please?
My colleague will pass on the memo, my lord. This 371J batch, my lord. Your lordship
Sir,
said,
appearing. Where is your colleague?
no, I'll hand over the memo to your lordship's court officer, my lord. Lordship only
Okay.
direct, my lord, matter to be listed anytime next week, my lord.
We have to see the memo first.
Please.
We have to see the memo first. Okay,
With my lords, kindly, my lord. Serial number 24, my lord, I appear for the petitioner. My lord, arguing counsel, my lord, he had to undertake travel today, my lord. May kindly have it any date, my lord. I've
Who is the
already
other
informed
side?
that
I don't want to oppose on this ground, my lord, but I only want to tell your lordships, my lord, this was a case of discharge from service in 2004. The CGIT, my lord, granted some monetary relief. Petition is, my lord, pending now for years. So I
you
only
are for the
request.
respondent?
Yes, my lord, I am for the respondent, the workman, my lord, who was discharged. He was acquitted in criminal proceedings, but my lord, the CGIT interfered and they thought the punishment was not, my lord.
You didn't challenge it.
No, I didn't challenge. No, I succeeded before I'm the
Yeah,
employee, my lord.
No, to the extent of compensation,
Yes,
you are satisfied?
yes, my lord. I've retired meanwhile. I have not received 1 rupee, my lord. 2004 discharge.
No, but what we have, and we can understand is the compensation satisfies all the claims.
Yes, my lord.
Including reinstatement.
Yes.
At the request of counsel for the appellant, re-notify petitioner, re-notify after vacation.
Let them pay us some money, my lord. At least some part of it they can pay me. I mean,
We will settle it, Mr. Naganan, not in interim. We'll
there's no
decide.
interim order. I have not even, I can take action against them for attachment.
How much was the compensation?
The court, my lord, only quantified and said I'm entitled to 80%.
Of the total
Last salary,
wages?
yes. That will come to, my lord, at least some 40-50 lakhs of rupees will come to.
Is it-
Let them pay me some money, my lord, is my request I make to the
Have it
other side.
after some holidays, Mr. Rahman. Give it 2020. last one.
2410.
Please.
My lords, kindly. List number 1, serial number 21, my lords. I would
Just
pray for a
1 minute.
week's time, my lords.
Just 1 minute, please. Just call the matters. Which one you said? 20?
My lords, serial number 21, my lords. Because the
You appear
arguing
for whom?
counsel, my lords, I represent the appellate, my lords. I've informed the respondents about the adjournment, my lords. Because the arguing counsel is unwell, my lords.
At the request of counsel for the appellant. On the ground that the arguing counsel is unwell, we notify.
1211.
Great.
Serial number 1.
My lord, appearing for the petitioner, my lords. My lord, the minor office objections, I'll clear them. My lord, may I kindly consider the interim prayer, my lords, may permit me
6
to.
weeks to remove the office of.
My lord, there is urgency, my lords.
What is the
My
urgency?
lords, 13 years have been contesting 2 suits and it has been decreed in my favor. Later on, the said proceedings has been initiated. Furthermore, if the trial commences, it will prejudice me. my
Is the
lords.
date? Charge is framed?
Yes, my lord, charge is framed.
When were the charges framed?
3 days back, my lords. My lords, kindly interim prayer may be considered, my lords.
You comply within 2 weeks. Okay? Just have it after.
A date may be fixed.
Yeah, we are fixing the date after holidays.
1510,
Okay,
Much obliged.
15:10.
serial number 2, Sri Manu.
I'm appearing for the appellant in this matter, my lords. 2 weeks' time may be given. We'll comply with
4
the
weeks to
Lord,
comply.
for the
office
respondent,
objections.
I appear for the,
interim order may be extended, my lord, since he,
I appear for the respondent number 1 and 2 in 2.1, my lord. Lord, the matters have been going on for almost 1 year. No, some peremptory orders may
You
kindly.
did say so. You're
Some
right.
perempt-
The objections we cleared within, say, 3 weeks. We notify if the objections are not cleared within 3 weeks, the petitions, writ appeal shall stand dismissed without reference to the court. Just give it,
my lords, interim order be extended in serial number 2.
if any, to continue.
There's no interim order in 2.1.
Yes.
That is all.
Interim order, where is the interim order,
Serial
please?
number 2, my lords.
683.
Yes. Yes.
Interim order, if any, in WA 683 of 2023 shall continue.
Obliged, my lord.
Great.
20th November. Serial number 3,
6 weeks to comply with the office objections.
2111, serial number 4, Shishu
4
Kumar.
weeks to comply with the office objections.
Interim order has to be extended.
Council shall also file the written submissions.
Interim order has to be extended,
Interim
madam.
order, if any, to continue.
Much obliged.
4.2, my lord. There is a delay and which has to be controlled to.
Just 1 minute.
But it's one recalling us also to be, one recalling.
You said what?
4.2.
4.2, my lord.
What?
My lord, the petitioner has filed a recalling application.
Why don't you use the mic? Yes.
My lord, appellant has filed a recalling application.
Huh.
There is a delay of 498 days.
498 days.
My lord, the appellant council has recently entered the Wakalat, my lord, NOC Wakalat, that's why.
Who, Mr.
It was not
Kiraj?
informed to the client, my lord.
Mr. Kiraj, J. was-
Kiran J.
You are Mr. Kiraj?
No, my lord, I'm appearing on behalf of,
You have filed your wakalat?
not filed the Wakalat.
Do that.
My lord, I'm appearing on behalf of this, same office, my lord. I mean, this is
From the office of Mr. Kiraj?
Kiran,
Yes, my
Kiran,
lord.
Kiran J,
Kiran
my
J.
lords.
Kiran,
Kiran J.
Kiran J.
Yes.
So what do you want?
My lord, delay may be condoned, my lord.
We will look into it. 498 days, we will look into it.
That's the interim order.
Interim order, where is the interim order?
In 1101.
Interim order, if any, to interim on, wherever interim order exists shall continue
Much obliged.
in the next date of hearing.
Much obliged.
2111. Serial number 5,
We have
We
the
to comply
respondent.
with the office objections.
Much obliged.
2111, serial number 6, Shri B. Ramesh.
Well, let's have the appear for respond number 3.
Yes,
I have to, my lords, I have to
My lords,
file, my lords, now they have also.
submissions.
my lords, I have a request, my lords.
Yes,
This issue is squarely covered by a division bench order as a submission, my lords. And in terms of my predecessor who has filed the written arguments, he has enclosed that. The division bench judgment very clearly provides, my lords, that they entered into a contract knowingly well that if they don't make payment within a certain time, the contract will rescind by itself.
My lords,
Only on this short issue, my lords, the issue is he was allotted, he did not make the payment, they cancelled it and allotted it to someone else.
why, what happened, Mr.? You did not file, Mr. Ramesh?
My lords, I'll file it, my lords, it is ready, my lords. Today by evening, my lords, I'll file it, my lords. Lords, I have to take approval from lords, the
You could
senior.
request the submissions be filed during the course of the day, list on 1410.
Much obliged.
Please,
1410.
Yes, ma'am.
please.
Obliged.
Deeply obliged.
Well, let's, we have filed a written
File,
submission.
Mr. Patil, you have filed your submission?
I have filed, my lord. My predecessor has filed.
Mr.
Lords,
Ramesh,
copy has not been served.
I'll
to me,
give
my
it.
lords.
I'll
My lords, I'll take it, my lords.
I'll give
I'll
it.
receive it.
you will file it.
Yes,
Today.
my lords, I will file it, my lords.
Respond number 3, we have e-filed it today.
You have filed it.
We have e-filed
And Mr. Patil, you also e-file it.
I'll e-file it.
You also, Mr. Ramesh?
Yes, my lords,
I
I
will
will
e-file.
file. E-file.
I'll e-file. Deeply obliged.
Much
7,
obliged.
serial number 7.
Yes.
Appointed to case.
7.
In this, I have to file written submissions. Ready, my lord, file it in the week.
Yes,
I appear for the respondent number one in this
I have
matter.
to file written submissions, my lord. It's ready, my lord. File it.
return submissions will be filed within 1 week. List on.
That's it.
511. Serial number 8, Srimati Vidyalakshmi.
Let fresh notice be issued to respondent
My lord,
number
this matter should
32.
My lord, this matter should be connected with serial number 2, my lord, arising out of the same. Because all the,
Both arises from the same order.
please, my lord, please, my lord, all the same, and all the parties are also same in both the appeals, my lord.
You said which number?
Serial number 2.
Serial number 2, my lord, 1101, my lord.
Serial 1101?
2, sir. Serial number 2 is 683.
Sorry, my lord, serial number 4, my lord, sorry. My lord. Serial number 4, my lord, 109, 1101, 1233, the same batch, my lord,
Batch case.
batch case.
What is the date given, ma'am?
In the 2111.
2111.
21. Let fresh notice be issued to respondent number 32, 41, 44, and 46. Returnable on
All the
2111.
matters, it has been served, my lord, the same.
You don't know, you will work it out. There, if they are there, it's fine.
Please, my lord.
But why don't you serve them again?
I'll serve the copy and I'll file a memo to that extent. my lord.
You
The
have-
already counsels are there, my lord. The same counsels in this matters. Also copy.
No, have you served these respondents?
Some respondents are placed, served.
We are
and
talking of 32, 41, 44, 46.
I will
You
do the.
serve them, returnable on 2111. We are having on the same date.
Please, my lord.
Serial number 9, government educate. 9.
In this, I filed a memo, my lord, along with the document I have filed. my lord.
Just say this, where is the, just call the council. Can we say that this may be tagged along with the batch of matters?
That's what my.
The learned counsel for the appellant submits that this appeal be tagged along with a batch of appeals, the lead one being WA 109 of 2023.
Please, my lord.
Next.
Grateful, my lord.
9.
Yes, Mr. Sriranga, what is this?
Number
Lord,
9.
in this, we have filed a document with memo, my lord. E-filing also done, my lord.
What have you
This
filed?
matter was heard.
This is in respect of rule was not complied. They have suspended and thereafter they have dismissed.
Lord, professor in my institution, my lord, it's a aided institution. There was he was on examination duty. In university, my lord, it was found that there was malpractice. University found, my lord, him to be guilty, and I was directed to take action. Government was also asked questions as to why no action is being initiated.
They have not obtained permission from our side and they have. done
Oh,
that.
this is that. Oh.
This that matter, my lord, for which I filed an affidavit.
What do you say? You filed certain bunch of documents?
No, my lord, I have filed only one document, my lord,
Okay.
along with
Same.
memo. It says.
What
e-filing
does
was
it
also
say?
done, my lord.
This document they had relied upon, my lord. My lord had directed them to file a translation of this. Now they have filed it.
Which is the document 2011?
Yes.
Now, how would this case help you, this document?
My lord. They have suspended much prior to it, my lord. They have dismissed, dismissal was also done by them. Without obtaining any permission, without intimating us, they have done 34, rule 34 was not complied with. Thereafter, we have sought, you have not followed the rules. You have to follow, which was not done, we won't grant permission like that, we have told. On that day also, they would have taken back him for duties. That was also not done by them. That was also not done by them, my lord. Thereafter, he is superannuated and he has been.
Lord,
They have ordered single judge. They are ready for both the project.
So why don't you, in a way, why don't you divide that half also, the rest half?
Lord, my instruction, my lord, is that when I have 4 employees, my lord, who are Lord, paid directly by the government because I'm aided. They pay the entire salary of this my lord, employee, my lord.
So that in fact, he also agrees, but he says since it was not with their approval, the liability shift
I
on
have
you.
now shown, my lord, that it was with their approval. In fact, my lord, this document, when he produced this document, my lord, I pointed out that this grants me possibly permission. My lord, then I explained, my lord, by way of an affidavit, my lord, which my lord has seen, my lord, earlier, 21/8/2024, I filed an affidavit. Along with that, I have produced document number 2, which is a communication from, kindly see my affidavit, my lord, dated 21/8/2024.
But what is the difficulty, Mr. Sriranga? How much is due now? 7 lakhs?
7 lakhs.
Why, is it possible to share the half?
No, my lord.
It's not. Very well,
But
we'll
there's a
decide it.
delay of 355 days.
We'll decide it. Yes, we will decide it this issue.
May I make one
Yes.
submission before this court, my lord?
Yes,
I may not draw your lordship's attention more than 2 minutes. If your lordships could kindly bear with me at page number 275. That's an order passed. by
Page
the
number?
President. Page number 275. May I take your lordships to 275 annexure F?
You said 17?
275, 275,
217.
275.
Oh,
This is an order passed by the learned
That's
single
right.
judge in Writ petition
Yes.
number 21595. Do your lordships have that, my lord?
Hmm.
Kindly turn to the next page, which is at page number 5. Paragraph number 2.
So
May I read
last
the relevant portion, my lord?
yes.
The learned senior advocates so and so appearing for the counsel for the petitioners would submit that the applicant is proceeding on a misconception. Kindly mark this one. The applicant is proceeding on a misconception as to the procedure that requires to be undertaken by the petitioners. The petitioners are before this court seeking sanction to place the applicant under the suspension for which prior permission is required under law before the proceedings can be initiated. This exercise had been undertaken by the petitioners earlier, but without having obtained the prior sanction, which was questioned by the applicant in the earlier writ petition, and so and so, had entered appearance, so and so. I pause here for a while and submit, my lord. This admission of a lapse on the side of the management would be sufficient enough for this honorable court, prima facie, to come to conclusion that at least now let them make the payment till the issue is decided, and it is between them inter se as to who is actually liable.
What according to you?
Yes.
Or who according to you is liable?
My lord, my submission, I'm not against both. In fact, I'm only entitled for my amount. I'm more so I'm just performing my duty here. Even though I'm appearing for a respondent, it is like an amicus. My respectful submission would be that as per this undertaking or the undertaking of acceptance of the lapse, admission of the lapse of on behalf of the management, having not followed the procedure, prima facie, though it is subject to detailed inquiry by this honorable court, but at the prima facie, glaring at this point, my submission is that the management would be liable. But however, it is subject to the consideration by this court.
Not
Okay.
this,
You want to say anything on this submission?
Yes, my lord, this was read earlier, my lord, just to clarify, my lord. We thought, my lord, we were under misconception because during the pendency of this writ petition, my lord, this order, this communication of 4/1/2011, my lord, was pointed out, saying that you have to take permission. My lord, the misconception, I thought, my lord, I was under misconception because, kindly see my affidavit for a minute, my lord, this 21/8. affidavit, in that document number 2, translated copy is at page 8. This is dated 17/9/2020. 17/9/2010. And the suspension order is 12/10/2010. Lord, this is a communication from the government to me based on university's query to the government. And second paragraph, Lord, it refers to Lord, the background in which Lord, Bangalore University has directed us to take action, etc. In view of the above, as the administrative board is the appointing and the disciplinary authority as per the Karnataka Education Act, Collegiate Education Rules of 2003, it is hereby directed for disciplinary action to be taken in accordance with the rule against Dr. N. Donnappa, and such action is to be reported to this office and Bangalore University immediately. So this is what they told us. Therefore, my lord, the process started reverse with the government telling us, please take action. Now, my lord, we proceeded because of those communications from the university and the government. Subsequently, government, my lord, writes to me to say that you take permission again. Therefore, my lord, a submission was made before the learned single judge to say, now that government has given us this communication that I have to again go back and seek permission. I went back to the government and asked for permission. They did not consider it. I had to seek a mandamus. They are today in violation of that mandamus, my lord. They never took a decision on that. And that is the predicament, my lord, in which I am placed. And my lord, after 1 year plus, my lord, they file an appeal against this order.
Thank you.
Grateful.
We reserve it.
That order itself says,
One clarification.
as per rule, in accordance with rules only, they have to act upon, my lord. I have a judgment on that point, my lord.
Very well.
I'll place all the judgments.
Only one
We are reserved.
submission.
Which are the judgments you want to file?
They should have filed it earlier.
This honorable court has taken a view that if the rule was not followed, they are not entitled.
I
The
followed.
judgments.
Along with memo, I'll furnish.
At
No,
least
just
if they
give
give
it.
us,
You just take those.
they
judgments.
told us, we could have possibly seen and distinguished.
Only one submission to assist this honorable court, if your losses could kindly
Yes.
permit me. May I assist, my lord?
Yes.
Please kindly take the date of the order at page 275. This is dated 4th of July 2011. Do you lordships have that, my lord, the order? 275. This is 4th of July 2011. After this order, there has been a communication which your lordships would find at Annexure G, page 282. This is relevant. And the date is also equally relevant. This is 5th of August 2011. In the sense, the management has in letter and spirit accepted its lapse. That is one aspect. Kindly see what the management says. It is though in Kannada, for the benefit of the other learned judge here, with permission, I would like to read in Kannada.
Yes.
ಮೇಲಿನ ವಿಷಯ ಮತ್ತು may I read in I am reading in Kannada, my lord, kindly pardon me. ಮೇಲಿನ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮ್ಮ ಮಹಾವಿದ್ಯಾಲಯದಲ್ಲಿ ಅಸೋಸಿಯೇಟ್ ಪ್ರೊಫೆಸರ್ ಆದ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಬೆಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಪರೀಕ್ಷಾ ಸ್ಪರ್ಧೆ ಎಸಗಿರುವ ಅವ್ಯವಹಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೆಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯ ವಿಚಾರಣೆ ವರದಿಯನ್ನು ಆಧರಿಸಿ ಬೆಂಗಳೂರು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಆದೇಶದಂತೆ
Which page you are reading?
page 282 annexure G, which
282 annexure G.
yes, it is in Kannada. Translation copy has not been furnished, my lord, so I am reading in Kannada. Kindly pardon me.
Yes.
ವಿಶ್ವವಿದ್ಯಾಲಯದ ಆದೇಶದಂತೆ ಸದ್ರಿ ಅವರನ್ನು ವಜಾಗೊಳಿಸಲಾಗಿತ್ತು ಮತ್ತು ಇವರಿಗೆ ಸಲ್ಲಬೇಕಾದ
Translation is at page 284.
ವೇತನ-
Translation is at 284.
It is better to read original text, my lord. That's what I feel. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ the relevant paragraph is para 2. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಅರ್ಜಿಗಳು ಇದ್ದ ಕಾರಣ ಸದರಿಯವರಿಗೆ ಸಲ್ಲಿಸಬೇಕಾದ ಬಿಲ್ಲನ್ನು ಕಳುಹಿಸಿದ್ದ ಕಾರಣ ಬಿಲ್ಲನ್ನು ತಯಾರಿಸಿ ತಮ್ಮ ಅನುಮೋದನೆಗಾಗಿ ಲಗತ್ತಿಸಿದೆ. So they admit that they are liable to pay those amounts. ಬಾಕಿ ಬಿಲ್ಲಿನ ಒಟ್ಟು 10,10,197 ರೂಪಾಯಿಗಳಾಗಿರುತ್ತದೆ. ಈ ಬಿಲ್ಲನ್ನು ತಮ್ಮ ಅನುಮೋದನೆ ಪಡೆದ ನಂತರ ಸದರಿಯವರಿಗೆ ಪಾವತಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು. They express their readiness and willingness to make the payment on acceptance of their lapses, and they say that you please sanction us and we are ready to make the payment and we are ready with the amount. That's how they say. So, this admission is
that's
in
compliance with the
continuation
interim
of the
order.
submission.
So there's a
This
direction in the
admission-
interim order.
May I complete my lord, my submission?
Yes, yes.
So this communication by the management in my respectful submission is continuation of the admission of lapse before the learned single judge.
Hmm.
So
Okay.
the lapse which they have admitted has attained finality. Now they cannot turn around and say, look, this is a different scenario, is my respectful submission. That's all is my submission here.
Okay, thank you.
Grateful for the cooperation.
Yes, next. Reserve.
The left-hand side of their documents, my lord, in front it says some misconception was happened like that.
You've
Kindly
given
see-
your judgments?
I'll furnish them. I'll furnish
Just
them.
give your judgments.
Yes, my lord, I'll give it. I'll give it.
Yes, reserve.
On the left-hand side, the members, list of the members can be seen, my lord.
How many are there? One or more than one?
Judgments, how many?
3 judgments.
Okay, give to the court officer. Next.
Serial number 10.
Then serial number 10, I beg to appear for the appellant's counsel, my lords. As directed, we filed our synopsis and submissions. I'm told late yesterday evening. I'm not sure it's put up before your lordships.
I appear for respondent number 4 and 5, my lords.
You have received the
Not
said, I will also file after receiving their submission.
The counsel, senior counsel for the appellant submits that the submissions have been filed in the registry yesterday. Let the copy thereof be given to the counsels appearing for the respondents who may also file written submissions within 4 weeks. List on.
1311.
My lords, may I make one submission in the meantime? There are 2 IAs, my lords. Could formal notice be issued? I'm not pressing the IAs right now. If not, because what has happened, the first IA, my lords, is the writ petitioner. After the writ petition came to be disposed of, he passed away, my lords. So his LRs now want to prosecute this appeal. So a formal notice is issued, at least one step will be.
Chandrasekhar, what about you this?
No, I'm appealing for R2 and R3 also will take.
No, then IA 4 of 24 and 3 of 24. At least 4 of 24, this is grant to
To prosecute the appeal.
to prosecute the appeal.
That may be granted.
Let notice be issued. Yeah, notice is accepted on IA 4 of 24 by the counsels appearing for the respondents, who may
Grateful.
respond to the same on the next date of hearing.
Much obliged.
Okay. Next.
Serial number 11. Checker.
Lords, I'll undertake to file wakalat to respondent. My lords, first
Ramesh was appearing. I filed acknowledgement on the office today. My friend is present.
You appear
Yes, my
for
lord.
one.
Yes, my lord.
Just say that Mr. Ramesh,
Ye
appears
Ramesh.
for, states that he shall appear for respondent number 1.
one.
Who appears for 2?
The
You
government advocate,
Government.
already your lordship had directed.
first. In view of the submission made by Mr. Ramesh, the notice to respondent number 1 is dispensed with. Counsel for the parties to file their written submissions along with the judgment they want to rely upon. Submissions of the respondent shall also
Yes.
deal with the application filed by the appellant seeking condonation of 586 days delay. Just
My
incorporate.
lords, now what as a matter is seized before the Supreme Court, my lords, indicate 28-1. It is listed on 1410, my lords. Lords, it could
We'll
be.
have it there.
Yes, my lords.
Just give it in November.
Yes, my lords.
1211.
511, my lords, your lordships has listed one matter on 511.
Identical.
Yes, my lords.
Some matters in the first court, some.
Today, the some matters are listed before this first court, my lords,
Today.
in
Oh,
serial number
then
58.
In any case. Okay, 511.
511.
No, that 511 is before this court?
Yes, my lords.
511.
Much.
Serial number 12.
I appear for the petitioner in this matter, your lordship. I submitted as a delay on my part from issuing the process fee and I've already issued it. Your lordship kindly register it.
Notice be issued to respondents 1 to 4, returnable on. Just say this. When did you file the process?
I had filed today, your lordship.
How will it go now?
There is no
Let we have been informed by the counsel for the petitioner that process has been deposited in the registry today. If that be so, notice shall be issued to respondents 1 to 4. Returnable.
Your Lordship, one submission. Last time Lordship had recorded, R2 is the central government. Only R1 notice need to be issued. R2 to R3 to 4 are former employees of the petitioner company. They are not required for this writ petition, Your Lordship.
Lords, it's only R5 I appear, my lords. R2 and R3 are the same petitioner only, my lord. Different division.
Your Lordship, only R5 is already present, Your Lordship. R2 to R2 is my Director General, R3 is my Director, and R4 is my former employer.
You are R5?
R5, you nothing. Only R1 is.
That in view of the order dated 2/8/24, comma, notice be issued to respondent number 1 on the basis of the process fee said to have been deposited in the registry by the counsel for the petitioner in the morning today, just say today, returnable on interim order to continue till the next date of hearing.
14/11
Much obliged.
for 13.
The order of contempt of the order dated 1st August 2023.
The order of none single judge has been stayed, my lords. They sought, my lords, we had filed a review petition seeking stay, my lords.
I think we have recorded this. I suppose.
Please, my lords, after that, the matter is.
My lord, I will point out the order passed by the single judge, which has to be complied with. Page 16, how they can contend now at this stage that income tax proceedings were initiated.
But that's on the merit now. You have to contest the review petition.
Review, but in the order itself, they have been provided to initiate. How they can say, I have already initiated and adjusted all the amount, poor man sufferings.
Now tell us one thing, is there any stay of the order of which non-compliance is alleged in the review petition?
The review petition is there, and in the meantime,
Then how can we proceed in this contempt? You have to work out in the review petition. What is the date in the review petition?
My lords, it was posted on 20th August, my lords. They sought time for filing objections to our review petition. They have not filed after.
What is the date now?
My lords, there's no date given.
And they have not filed the reply also here of this contempt.
That we will ask, let the first review be decided. We have been in on the last date of hearing, we have noted, we have passed the following order. To stop, though according to the counsel for the party, there is no date has been given in the review petition. So if that be so, we re-notify the matter, just give it end of November. Get your review decided.
28/11. For 28/11. Serial number 14.
My lords, item 14, I have. Yes.
Pass over, Mr. Arbati, we'll come back.
My lords, 230, my lords, item 14, could I repeat?
We can't say, Mr. Gautam, but let's see it.
Wait.
Serial number 15, 388/7.
In this, my lord, we have complied with 11 objections. I am appearing for the appellant. And second submission is that one Gauramma died during the pendency of the writ petition, and she died issueless, Your Honor. Therefore, she has the same is mentioned in the writ appeal also. So that objection may be overruled, sir. And my IA is pending for restoration of this appeal, my lord, which was dismissed for non.
Let's see, have you cleared the objection?
Yes, sir. My lord. Yes, my lord.
What is the report? That's right. What about the other objections? But what is this application bringing LRs on record?
That is after restored this writ appeal, then we'll make it.
Different respondents?
Appellants, they are appellants, my lord.
Not Gauramma.
Who were Gauramma, not Gauramma. After this appeal is restored, then we'll
But how do we get that the objections have been removed? Okay,
Yes.
we can record it. We can restore it. So we can record it, except. Is it? Let's see that. 10-10-23. How many times the appeal was dismissed earlier?
No, my lord, it does not dismissed. It is for the first time.
The IA 1 of 23 is for recalling of order dated 10-10-23. The learner counsel for the appellant submits that except one objection, all the objections have been cleared. To stop in respect of the one objection of the registry, that the loss of petitioner number 1C.
C. Gauramma.
Srimati Gauramma. Petitioner number 1C, Srimati in the writ petition, namely Srimati Gauramma. Was she in writ petition?
Writ petition number 4302/2008. 4302/2008.
Has not been made a party. How do we get that? Where is that? 20? One C. Writ petition number 4302 of 2008.
8.
Not made a party in the present appeal, in the writ appeal. The council clarifies that Gauramma has expired issueless.
Issueless, yes.
And as such, no application for bringing the LRs have been filed.
Please.
To the extent of Gauramma, the appeal stands abated.
Yes, please.
And abated. Full stop. Noting the said submission, the objection is overruled. Full stop. In view of in reading the contents of the IA number 1 of 23. So IA number 123. Reading the contents of the affidavit in support of the application, being 1 of 23. Where is your prayer? The order dated 10-10-23.
Yes. For non-compliance of office objections.
Whereby the court has dismissed the appeal for non-compliance of office objections. He is recalled and the appeal is restored to its original number. To establish the appeal for preliminary hearing on.
Please.
1411.
Next.
Please.
Number 16. 16, Sri Lokesh.
Yes, sir.
This can be heard.
Kindly grant me some time after.
You are ready?
After vacation, immediately after Dasra vacation.
Adjournment is sought by the counsel for the appellant, re-notify on. Just give it date according to our convenience.
20th November. Serial number 17.
Next.
17, Sri Malipati.
First respondent.
A date may be fixed post vacation for hearing.
Pardon?
A date may be fixed, my lords, post vacation.
I have filed an IA for early hearing, my lord, because of this pendency of this appeal. They are not implementing the order of the learned single judge. Therefore, my lord, I have not submitted. It has to be taken up today itself. I only request your lordship to take it on an early date.
Seventeen. Who is the counsel, ma'am?
Well, it's my Mali Patil PS.
What is the difficulty?
Lords, there is some inconvenience today, my lords.
The request of counsel for the counsel for the appellant, on behalf of the counsel for the appellant, re-notify.
2111,
Next.
serial number 18. Date here, Manu Kulkarni.
My lords, I appear in 18, my lords. I am requesting that your lordships may consider, my lords, IA 1 of 2024, which, my lords, I have filed as the writ appellant, seeking, my lords, production of the review order that the union now says they have filed. May I just in 1 minute, my lords, place the facts? I am Twitter.
Yes.
There were, my lords, a
Yes.
series of orders on Twitter to take down certain content in terms of blocking content under the blocking rules, my lords, under the Information Technology Act. There was some delay in compliance, back, forth, etc., my lords, but ultimately Twitter complies. Twitter then challenges those blocking order post-compliance before this honorable court by a writ petition, seeking, my lords, that the orders do not have reasons recorded. Reasons are to be under section 69A of the IT Act and limited reasons based on the 19(2) limitations, my lords, of the Constitution. In the absence of this, such an order which is omnibus is not to be complied. Although we have complied, this must be quashed. The learned single judge, my lords, holds in our favor on locus. Also holds in the favor saying that the order that is passed for blocking should actually be supported by reasons. But makes a distinction, my lord, saying that recording of reasons is one thing, but communicating that reasons is yet another. Whilst reasons should be recorded, reasons need not be communicated. We file an appeal, my lords, before your lordship's court, predominantly on two grounds. That the dichotomy between recording reasons and communicating reasons is no more res integra, because Shreya Singhal, my lord, seals that issue by saying that the order itself must contain the reasons, which permits an intermediary to challenge under 226. My lords, when the writ appeal was filed, of course, there were costs, my lords, there is an interim order on cost, I've paid 50%, etc. But for the first time in the objections before the writ appellate court, union, my lords, takes a contention that the orders that were passed to block were subsequently reviewed, my lords, under the same rules by a review committee, my lords, which is a review committee under the Telegraph Act headed by the Cabinet Secretary. And the review committee has actually confirmed these orders. But they say the order passed by the review committee is top secret and therefore will not be produced. My lords, we file an IA saying that we challenge an order. If the union says that order has been reviewed and confirmed, then I must be given the benefit of that order. And today, my lords, that issue. Sorry.
Tell us, Mr. Puvaya, was the file produced before the court?
My lords, not the review file, my lords.
Perusal.
Not the review file, my lords. The first file, my lords. In fact, we have also
the earlier order.
My lords,
The earlier decision of the
earlier
first
decision
authority.
Yes, my lords. The first authority that the designated officer's order files were produced. They were produced in a sealed cover. And in fact, my lords, the orders that were produced in a sealed cover, some of the orders I have access also, I was given. I have, my lord, made my submissions on them.
But tell us why can't be in a way that appeal be heard rather than why on a IA then?
Yes.
My lords, two submissions. I'll just make two. My lords, I bow down. I'm ready, my lords, on the appeal. At my lord's convenience on the roster, my lords, I will argue the appeal. But may I make just one submission for my lords to consider? My lords, an order is challenged. The order is reviewed. My lords, today the review order issue also is not res integra, because in the Kashmir issue, my lords, which is the Association for I think it was, my lords, the Foundation for Media Professionals. In 2024, the Supreme Court, my lords, specifically directs that when there is a blocking order and there is a review, that review order also, my lords, must be produced. Therefore, my lords, if the review order is produced, the reasoning in the review order may or may not assist me. In my view, my lords, will assist me, because the review authority would have considered, my lords, either the same ground or would have considered a better ground. If it's a better ground, my lords, it may assist me. If it is the same ground, then, my lords, the fruits of the poisonous tree issue, my lords, applies. Then the review order, my lords, cannot be used as a set of crutches for the union to say a highest authority has reviewed it and therefore it is correct. My lords, may I make last submission?
Yes. Yeah.
Even if the review order is not given to me upfront, let them produce the review order before your lordships. My lords may consider, my lords, looking at the review order and whether I must be given a copy or not. In the meanwhile, my lords, your lordships may fix a date for the final disposal. I will be ready, my lords. I'll physically come to court to argue the matter.
What do you say, Mr. Khan?
Lord, my first submission is that the appellant before your lordship is a mere intermediary and is not at all the actual aggrieved party in respect of the directions which were issued for closure of the accounts and certain tweets. Lord, there was a certain time when there were a lot of fake tweets which were originating from a neighboring country. And then we have taken steps to block those tweets or block those accounts. Now, the consistent stand of the appellant before your lordship was before the single judge.
Yes, appellant is only a platform.
Yes, he's consistent on, he's a mere intermediary. He said, I'm not the author. If he's not the author, my lord, how is the appellant concerned with the blockage of those accounts? Why does he need to see the review documents? First, he should cross the hurdle of demonstrating before your lordship as to how he is aggrieved by the blockage of the accounts.
But according to Mr. Puvaya, the locus has been established in his favor.
No, Lord, that has been considered. At the time of finally, your lordship will consider this.
What do you say on the record? What he is saying there, at least for the perusal of the court.
No, we can produce it before your lordship. There is no difficulty. But then, Lord, the very question whether that needs to be reviewed may be considered at the time of final hearing.
There are two things, Mr. What he is arguing is only arguing something that it must be given, something that he is arguing, whatever the review, whatever the initial order. But alternatively, can the court look into it and then decide whether it can be?
Certainly not. Our objection is we will not produce it to give a copy to him.
To them.
We'll definitely produce it before your lordship, my lord, if we are so directed. But my lord, whether we should do it or not, lordship may consider at the time of final hearing is my request.
My lords, just 2 sentences, if my lords permit me, my lords, in response.
Yes, 1 minute, Mr. Puvai.
Yes,
1 minute.
Yes, please.
We'll set out for hearing then, Mr. Puvai.
Yes, my lords. May I just, my lords, utter 2 sentences, my lords? I won't take more
Yes.
than 30 seconds. My lords, of course, the first sentence is a repeat. The learned single judge, my lords, in page 22 of the order, indicates that although I am a corporate entity, I have the locus to tap the writ jurisdiction of this honorable court. The union is not in appeal over it. Second, on the issue of, my lords, I being a mere intermediary, that again is not res integra because section 69A, which came in by an amendment, imposes penalty of 7 years on the intermediary if the intermediary does not comply with an order. Therefore, if an order is passed on me to take down content of the author of which can be whoever, I am entitled to know the reasons. And if I don't comply, I have a 7-year imprisonment. Now, the union says, when I challenge Puvaya, you are a mere intermediary. But if you don't comply, Puvaya, you go to jail. Now, if I'm an intermediary, let the union say that they will have no cause of action against me or penalty. I have no problem. If I have a consequence in the law, I am entitled to challenge it. Lastly, my lords, I do bow down that let them produce the file before your lordships. Your lordships may consider it. But I would, my lords, request that the union looks at its own position. The Solicitor General, in the Foundation of Media Professionals, makes a statement to the Supreme Court that review orders passed under this very rule will be made public, and that is recorded and taken, my lords, as a statement of the union. Now here, my lords, the union holds a different story.
We will see that. We will see that. We'll set up. You keep the records with you. We'll see it. Just say that list the appeal for hearing on. Counsel for the parties shall file their written submissions, if not already filed, within 4 weeks. List in first week of November. And date
6/11, sir.
6/11.
My lords, may I'm sorry, my lords, with my lord's leave, my lords, may make a request for anything other than that week, my lords. There is a part heard which is fixed for that week, my lords, in the court.
Just give the week thereafter.
Sir, 12/11.
Please, I'll then. I'm very grateful.
Yes.
Serial number 19. Contempt. R3, my lords, filing comparative table.
I seek a 2 weeks time in this case, my lord.
Kindly
In
pass
16,
over
my
the
lord.
matter, my lord. Senior counsel on
16.1.
his feet, my lords, in other court.
There are service is still pending in 16.1, my lord. If that is completed, both the matters can be heard together.
Yes, my lords, please.
In case in connected matter and filing memo regarding the process report. Yes, yes.
Serial number 20. Chechen Basuraj.
Would it be taken up tomorrow, my lord? Yes. No, last occasion, my lord, your lordship has passed a detailed order asking the authority to get instruction. Whether the appellant, my lord, was appointed as against the sanction post or not, in view of the annexure R2, my lord, it is specifically said, your lordship can kindly see the earlier order.
As regards the detailed order, my lord, I am sorry, my lord, I am not really aware of the order passed, but I'll read. Please.
Paragraph 43 this thing is where there is a regularity that can be overcome. If it is an illegality,
It can.
What ultimately the case is, he has put in that 10 years of service time, the benchmark. So we said that you must at least say that take instructions. He relied upon Mahadevi to contend that has been appointed against a sanction court. Even the appointment is illegal. He cannot be denied the benefit of the order. So, but there is only one thing. What the signature just said is he has attained the age of requirement.
Yes. post the retirement regularization, my lord, cannot be considered.
Tell us when will the regularization relate back? So today you have attained the age of superannuation, so it cannot be today.
But he was appointed as against a post which was temporarily created. It is not a post which was created permanently. The government has said the appointment is for a particular period. Thereafter, his services was continued. He continued in the same post up to the date of. In fact, government has rejected our proposal in the year 2013 itself. Annexure R1, which have produced along with the statement of objections. That order was not questioned by the petitioner.
Then after soon after completion of 10 years, what my appointment, initial appointment was 1986, my lord.
86.
Please.
When did you file the
Petition, my lord, 2014.
11.
2011. 11.
14. 14.
14. Yes, my lord.
That's in 2008, page 115, annexure S1. But he has approached this honorable court by in 2004, WP 4854. Yes, pursuant to the direction issued by this honorable court, an endorsement was issued by the government as per annexure S1, page 115. The translation is at page 118. That the government has refused to accord approval for regularization of the service of the petitioner on 4 grounds, which have indicated in page 120. This. Yes. Next, the said post should be a sanctioned post and it.
Type. I initially typist, my lord. Thereafter, my lord, by
this order became final, my lord. This was not questioned. Please, minutes.
But he didn't have 10 years. Once he has been appointed in 86. When you say it's not sanctioned,
yes.
But we challenge this 2008. So, the age of superannuation.
To 2017, my lord, 17.
He has put in 31 years of service.
Therefore, his case was considered under 2012 rules, which granted protection, service protection, and also payment of ex gratia for every year.
He get ex gratia under whose act?
He is eligible to get the benefit, but he has not accepted that annexure R2, which have produced in the statement of objections, page. That The state government has produced the rules minutes. At annexure R3, page 120, 174. 180, page annexure R4, page 180.
Yes.
Yes, my lord, the employees who are considered, my lord, under this rule, my lord, the name of the petitioner finds placement, my lord, page 188. 188, serial number 18, my lords, in the English translation, my lords.
196.
196. Mr. H.S. Raghavendra.
Yes.
He has been considered under 2012 Act. But he would be entitled to the benefit under the 2012 Act.
So what are the benefits you would do?
That they'll get salary of salary for equivalent to 15 days of pay for every years of service minutes from the day. Yes.
86.
Yes, minutes.
Why don't you take it? And they have an ex ratio also under the act. Is it under 2012 Act?
12 Act minutes. I've stated, my lord, in the statement of objections, page 204.
Why don't you take it? They're getting better rather than, and I think this act has come after the
Yes, 2012 minutes. In order to, my lord, give service protection to the persons who are not regularized pursuant to the orders of the Honorable Supreme Court.
basis.
Kindly pass it over, my lord. Please.
Please.
21 urgent. 32, Srimati Sujata.
Here for respondents 2 to 5. This is the
Kindly, my lord, I'm sorry. Sorry, minutes. Can it be taken up tomorrow, minutes?
Tomorrow.
In the meantime, I'll get instructions how much he will get under the act. How much would be there?
Just see how much is being
Yes.
contributed
Yes, I shall do it.
tomorrow.
Please.
Appellant by me, my lord.
The first respondent.
and for respondents 2 to 4.
Appellant by me, my lord. Appellant is the purchase of scheduled property bearing site number 10 situated at ex-serviceman colony, Banaswadi, Bangalore, measuring 30 into 40.
I will give the dates
It's
of
purchased from G. Papaya Reddy, son of Gurumurthy Reddy, my lord. Appellant had entered into an agreement with vendor on 18/5/1982.
Yes.
that I am permitted to give the dates of events.
We just pass over, we'll come back.
May I make one submit? Last time, my lord, it was listed. Unfortunately, it could not reach because of Mr. Gautam's case that my lord, is a matter where for the last 40 years, my lord, my client has been paid.
Yes, ma'am.
The appellant had entered into an agreement with vendor on 18/5/1982, my lord. Since 1982, the appellant is is literally in the possession. The khata is entered in the name of the appellant by BMP, Bangalore Mahanagra Palike, in annexure C, page number 52. The appellant has paid the taxes to the BBMP and marked as annexure D1 to D5.
Respondents 2 to 4, my lord, the allotment of the site.
Yes, ma'am.
R1 is BDA and R2 to 4 as the allottees, ma'am. and paid taxes to the BBMP and marked as annexure D1 to D5. That's page number 55 to 58, my lord. Water bill stands in the name of the applicant, page number 69, as well as they have the current bill, connection, sanitation, all the amenities provided by the BMP, that is Bangalore Mahanagra Palike. The property claiming by R1 is BDA, my lord. The suit scheduled property is since 18/5/1982, the appellant is literally present without any interference from anyone till 2006. 2006, my lord, the respondent number 1, along with respondent number 2, that is 2 to 4, appears before the appellant and claims possession, my lord, or acquisition, claims possession and try to interfere in the social scheduled property. The property is measuring 30 into 40. The property measuring is acquired by purchased by the appellant is 30 into 40. But the dimension the respondent number 1 is claiming is 50 into 80, my lord. The extent is east to west at 24.40 and north to south 15.25, totally measuring 372.10 meters, which is converted 4,035.54 square feet. But actually the property purchased by the appellant is 30 into 40. And coming into date of agreement, my lord, date of agreement is 18/5/1982. Date of agreement of respondent number 1 to respondent number 2 is 7/1/1986, my lord. And sale deed entered into between the vendor and when the appellant is 23/10/2000, whereas R1 to R2 is 10/1/2007, my lord. Comparatively, the previous agreement holder as well as sale deed property owner is the appellant, my lord, page number 37, my lord. And the measurement is 30 into 40. Now, although we are in the position of 30 into 40, the claiming by R1 to R1, R2 to 4 are 4,000 and odd square feet. The remaining measurement 2,800 is sold by the same vendor, who is G. Papaya Reddy, measuring 2,800 square feet, which falls to Sunita Rajshekar. Sunita Rajshekar is none other than daughter of Jaipal, my lord. Appellant is the prior purchaser and R2 to 4, then R2 to R4, my lord. Appellant is the innocent purchaser. She's eligible under section 38 clause D of the BD Act, my lord. The appellant submits that the respondent is no point of time acquired the said property, much less took possession of the property than the petitioner at any time, even if it is acquired once possession is not taken. Acquisition lapsed as held by the Supreme Court report in 2011, clause 3, SEC 139. Hence, 24 clause 2 is applicable when such being the case, the whole acquisition gets vitiated as held in ILR 2015 KR 3267. Hence, in view of the said fact, even if there is any acquisition process taken place, once the possession is not taken, appellant has been continuous possession. If any acquisition is not completed, it gets lapsed. The appellant in possession since 2082. When it goes to page number 37, my lord, agreement entered into between the appellant and the vendor is on 18/5/1982. In 2006, my lord. Yes, my lord. In 2006, the R1 and R2 present before the appellant came before, tried to interfere and disposes the appellant from the suit schedule. Whereas it was purchased in 1982 prior to the purchase of the R1 to R2 to R4, my lord. They tried to interfere in the suit schedule. Hence, we have filed an OS number 9459 in the year 2006 before the civil court seeking permanent injunction, which came to be disposed. But hence the appellant filed an RFA in 1641, 2014. Even that came to be disposed, stating that the proper approach to the court is by filing a writ petition. Hence, writ petition was filed since 18/5/1982. 82.
20.
Illala, adu registration date. Registration sale deeds were registered on 2000, my lord. Agreement and GPA was registered on 1982. Please consider page number 37. My lord. G. Papaya Reddy, major son of Gurumurthy Reddy, residing at Dodbanaswadi. His GPA holder Ekambaram. Ekambaram is none other than the husband of the appellant. Vide GPA dated 80. Yes, please, my lord. Prior to the agreement entered into between the R1 and R2. R1 and R2 was entered into an agreement in the year it's prior to in the 7/1/1986, my lord. The appellant was an innocent purchaser. She was illiterate person. She was not aware of the transaction taken between R1 and R2, my lord. Prior to that, she has purchased. The property lies within the purview of the BD. Possession 77. 3/11/77 preliminary notification and final notification date 13/11/2018. 3/11/1977.
Okay, and when was the final notification?
13/11/1980.
Purchase day after even.
Power of attorney come sale agreement, my lord.
So after that also is after
Prob-
final notification.
Probably,
So
probably.
anything which is bought after final notification according to.
But then one point to be noted, my lord, the award amount was not transferred to the Papaya Reddy, who's a vendor of the appellant, my lord. Rupees 67 and odd was. No, my lord, she's purchased the property, sale deed is in her name, and she's paying taxes to the BBMP.
Saying that.
No, even after the acquisition, possession is still not, even adversely, we are in the possession, my lord. And she's an illiterate person, she's an
Yes.
Some of them received. Some of them andralli, adರಲ್ಲಿ Papaya Reddy is not there.
Yes, ma'am.
Others who are the brothers and sisters of the vendor, they have received the compensation.
Some
Of their share.
Not the vendor, my
of
lord.
who are not received, we have deposited in the civil court.
You have deposited, but it's not been received by the Papaya.
The R7,
It's for you to work it out with the LSC.
LSC, in the year 83 itself, my lord, 19/4/83.
After what was passed and what is their power of attorney date?
18/5/1982. 5/1982. But then the appellant was an innocent purchaser, and the vendor has formed a layout saying ex-serviceman colony, my lord. It doesn't come into the property of the BD at all. It stops right to the property. Immediate right.
You have after the final notification has passed.
I have got one judgment, but not intimated to the appellant till 2006, my lord.
Was for injunction.
Yes, permanent injunction seeking restraining the defendant from not to interfere in the suit.
Dismissed.
Yes,
Appeal also
hence
dismissed.
they filed an RFA, my lord. Also dismiss seeking that the proper approach to the petition, writing the petition.
Of acquisition.
Yes,
So far as injunction is concerned, that gets rejected.
it was.
Petition, you file the petition, petition has been dismissed.
But we are in the adverse position, my lord.
This petition also is not for, my lord, to challenging the acquisition, my lord. Writ petition is also not for challenging the acquisition. My lord, petition prayer, kindly see, my lord, ink page 12 to 23, my lord. 12 to 23. The prayer in the, let's see the impute order says.
Yes.
Here in the writ petition, my lord, to declare that the petitioner scheduled for.
Applications have not been.
No, my lord. So that's for declaration, my lord, in the writ proceedings.
My lord, taking into time into consideration, she's an illiterate person. She's a legal purchaser, my lord. She was innocent because she was not aware of the acquisition by the R1 and R2 entered into transaction. She was an illiterate person, man. And the agreement.
So far as the petition is saying, you say it has been deposited.
Yes, yes.
It has not been received by the.
Yes, my lord, entire my lord, the site in question is formed in the survey number. My lord, my compile, the synopsis may be kindly be taken, my lord. Dates of events I have given, my lord. My lord, this property is the site number 3M516, measuring 58, my lord. This is carved out of the two survey number, my lord, survey number 234 and 239 of Parasavadi village. The two survey numbers, my lord, including some other survey number, we have acquired for the purpose of formation of the layout called, my lord, Old Madras Road.
OBM.
And how did this respondent number to we have?
Because this site
No,
in
you
question
are
was
allotted.
allotted to the husband, BDM,
Please,
to
madam.
the husband of the first. Husband of the first petitioner and the father of the two to four original alert. After his death, my lord, they have succeeded.
Original allotee, my lord, is one Dr. Sheshadri, my lord, to whom it was allotted, my lord, on 1/3/1985. And he died a premature death.
Yes, cost has
Yeah,
been.
1982, since 1982, she is in the possession. She's a legal purchaser. She did not acquire the property by anyone, only by through vendor is G. Prapaya Reddy. He formed a layout state in ex-serviceman colony. Ex-serviceman colony exactly starts from the property which ends in the BDA property, my lord. Its property is somewhat curved, my lord. Adike, they claim compensation, they are claiming that this property belongs to the R1 anta. Even the measurement is put in the Annexure A, which is the sketch copy of the thing. Right exactly starts there, my lord. A TI order may kindly be considered, my lord, till the pending disposal. TI order may kindly be not to dispose and interfere until the pending disposal of the appealment. TI order may kindly be considered until the pending disposal of the petition. Yes, please. Yes. No, yes, please. I'm ready to pay the compensation. 25,000 deposit, Matthews. As per the order of the writ petition. Until the pending cost we are ready to pay shall not be dispossessed, my lord. Since 18 for 40 years we are in adverse position.
I got the photographs. It's only a 10 by
I'm also
20
protesting from
set.
photographs, my lord.
Okay, kindly.
The presence of
She is
the.
residing, my lord, in.
One more submission, my lords. Under section 38D also, the neighboring person called as Jaipal, he has granted relief in WP number. Until then, not to dispose us, my lord.
Case of the appellant is that he had purchased the site number 10 at a schedule property in the ex-serviceman layout as a FIR on 23/10/2000. He was issued a khata by Corporation of City of Bangalore and a house we were living there by paying taxes and water charges to the corporation. For the case before the single judge, at no point of time the site was acquired by the respondent number 1 VDA. When VDA sought to interfere in her position, she filed an OS 9459/6 against VDA. The said suit was dismissed. She filed RFA 1641 of 2015. The said appeal was disposed of. Disposed of owing to the suit questioning the validity of acquisition proceeding was not maintainable and should be challenged only in a review decision. It may be in the case of the VDA. Before the single judge was that a preliminary notification was issued on 11/1977 and a final notification issued on 15/11/1980. When the name of FIR as owner of the land. By this notification, what was acquired?
The land survey number.
For layout formation of OMBR levels.
The land in survey number 234, measuring 5 acres, 15
Yes, yes.
239, my lord.
230.
8 acres and 5 quintas was acquired.
Yes.
For the formation of the
OMBA layout. Old Madras. OMB.
Old Madras Road and Banaswadi Road layout.
for forming the layout.
Yes.
For forming the old Madras Road and Bansawadi Road.
Banaswadi.
When we are layout. Layout. Full stop. Thereafter, the law dated 21/1/1950 was passed. The compensation has been deposited. The compensation has been deposited in the civil court.
Yes, my lord. The part of the amount was paid and part of the amounts was deposited in the civil court. Para 5, my lord. In the sub para 5, my lord.
So,
And second page top.
Roman 5.
They've deposited the amount in favor of other petitioners, other vendors, my lord.
it is civil court. Full stop. It is also stated that possession of the land in question was taken on 5/2/1983 and 18/3/1983 respectively. Full stop. The case of the appellant was also that since there was a failure on the part of the mediator to take possession, among the acquisitions should lapse as per the decision of the Supreme Court. The judgments dated in the judgments listed. The respondents 2 and 4 were also appeared before the learned single judge. Submit that this land in question, what is this site in question?
Site. Yes, my
Site
lord.
measuring 13 to 40.
516.
Question that is 3M-516 was allotted to
Measuring 550 by 8. Please.
there In favor of the respondents to the court on 10/1/2007. Let's start. The submission on behalf of the appellant was also, since no notice has been issued under section 9 of the Land Acquisition Act for taking possession of the possession, and the position continues with the appellant, acquisitions to lapse. The single judge, on the basis of the case set up by the parties, has in paragraph 12 onwards stated as a there is no dispute. There is no dispute that the case of the appellant was that she had purchased the site in question on the basis of a power of attorney and an agreement to sell in the year 1982. It is repeatedly after the final notification was issued on
13/11/1980.
13/11/1980. Also, I considered that the suit was filed by the appellant against the BDS seeking injunction in the year 2006. That is much after the final notification was passed, was issued, and also the land was allotted to the predecessor in the interest of respondents 224. The appeal thereof was also rejected. The stand of the appellant is that the suit was disposed, the appeal was disposed of on the ground that acquisition would be challenged only in the petition. So we have seen the heirs as a great fall in the petition. And also noted, which are also noted by the double single judge. Considering there is no challenge to the aforesaid preliminary notification of the final notification in the petition. What is the sought?
Is for declaration.
What is sought is a prayer appeal to injunction. The state prayer appeal to injunction, which aspect has attained primarily the dismissal of the suit, which order has not been accepted by the appellate court. The single judge is justified in relying upon the judgment of the Supreme Court in Delhi Development Authority versus MGS India Private Limited and others. 2023 SCC online SC 154. That the subsequent purchaser is not entitled to maintain a petition challenging the acquisition. They say after that Shiv Kumar and another. Shiv Kumar was a Union of India. Reported in 2010 SCC. The two requirements in terms of the judgment of the Supreme Court and also in terms of section 24(2) of the right to pay compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2000. With cost of 25,000.
Prakash Patil.
Petitioner. Yesterday's matter, my lord. Please.
Cost may be, my humble, cost may be.
Waive the cost. If you waive the cost, with the appeal But waiving the cost imposed by the learned citizen.
Yes, please. But the dimension was they're acquiring was different from what ours was 3014, my lord, or the 4,200 square feet.
Paper petition, ma'am. Yesterday, I requested my learned friend to make a proposal so far as the final settlement is concerned, my lord. They were required to convene the meeting of the board and respond my request, ma'am. Withdraw this, work it out with it. You will withdraw this. If anything, you want to work it out with it. But in this regard, I'm permitted to make few submissions. My lord, during the COVID-19 situations repeatedly, I have approached this honorable court, debt recovery tribunal, as well as debt recovery appellate tribunal, and the writ petition. Please. Appellate order. Please, I approached my lord. But this honorable court was pleased to entertain the previous writ petition and interlocutory applications also, my lord. However, I could not comply with the conditional orders that were passed by this honorable court, my lord. I challenged the order passed by the debt recovery tribunal on 22/11/2019, my lord. And extension of time was rejected by the honorable tribunal. And that's in the month of December 2019. And thereafter, during COVID-19 period only, I approached the debt recovery appellate tribunal. And the debt recovery appellate tribunal, considering the previous petitions, declined to condone the delay, my lord. My humble submission is, my lord, there is no question of condoning the delay as such in view of the order passed by the Honorable Supreme Court, that the limitation period itself has been extended in respect to all these special enactments also. How will that recognition of
One submission, madam. I am not going into the merit of this case, whether the legality and validity of the order passed by the DRAT. And with regard to the very initiation of the surface proceedings without classification of the loan account as NPA, and the reserve price fixed according to their whims and fancy, that apart, my lord, irrespective of some of the irregularities committed by the respondent bank, I am before this honorable court. Please, I am before this.
You tell us how will you cross that hurdle?
Please.
See, you were so active in the proceeding before
Please.
this court. Would I have approached there?
My lord, I am from Mysore, man. The writ petition is filed before the bank, High Court of Bangalore, my lord. The DRT is in Chennai, my lord. So that
This should be a criteria for conversion of.
my lord, in fact, my lord, I am not pressing into the merit of the case or so for the legality and validity of the order passed by the DRT at this moment, my lord. I am only seeking the equitable relief at the discretion power of the honorable. Please. Only, my lord.
But not in this facts.
Please. Only I would like to seek the attention of the honorable court regarding the consolidated statement filed by them, my lord, in the for a moment. Page number 211, my lord. This is the consolidated statement as on 30/9/2024, page number 211. In the reply filed by them. Please, my 211, my lord. Annexure R28, my lord.
You have.
No, they have filed. The reply filed by the respondent. 211 in the reply filed by the respondent. Objections filed by the respondent. Annexure R28, my lord. It in the writ petition, it is. In the reply, my lord. Okay. In the statement of objection filed by them. They have filed the statement of. Please.
Yes.
My lord, the
Loan was sanctioned on 16/1/2014, third column, sanction date, my lord. Loan amount was 25 lakhs. Right side. And once submit to come. And as per this consolidated statement, my lord, the principal amount due is 21,92,659 out of 25 lakhs. And interest is 17,20,926, my lord. And the other expenses amounts to 12,09,697. Other expenses, including legal charge, paper notifications, all those things, my lord. And towards it's a security guard charges, everything. And thus, they are claiming the total amount as due as 51,34,142, my lord. Against 25 lakh rupees availed in the year 2014, I have repaid undisputedly 36,50,000 rupees. And if that be considered, my lord, hardly only 3 lakh rupees has been adjusted towards the principal amount in 10 lakh. Now they are claiming 51 lakhs in addition to that. 51 lakhs plus 36 lakhs, nearly 87 lakhs I am required to pay within a period of 10 years for 25 lakh rupees, madam. This may, and this is contrary to any banking practice, and even if this fact may kindly be considered by this honorable. Please, madam, that's what I am. For this, my humble submission is, I will find that please. Many applications you have filed? Please, more than 4 writ petitions and more than 5 interlocutory applications. Every writ petition, My lord, this honorable court, please, madam, this honorable court was pleased to entertain, consider my request, my lord. I shall begin. How many times? Please, madam. We can't take that argument. As an, You have been please, requesting, the please, court has been accepting, and you have been violating. please. My lord, this is my, You will not take my, it I made it clear to my client also while filing the writ petition, this writ petition also, that this should be the final, this should be the final chance in the hands of my lordship on that I would. Right, please. Submissions you made in the past. Please. Court has, every time the court has accepted. Please, your- please, Now, but we will put it to rest. please. Please, my lord, one submission. In the factual background, my lord, I approached the respondent bank with a request to, We have been saying, drop this appeal, go to the bank. We say nothing. my lord, in, We will not add one word extra. this is the final submissions, my lord. I don't. In the factual background, I approached the respondent bank with a request to grant me the benefit under the one-time settlement scheme, my lord. The respondent bank has issued the endorsement stating that OTS is not applicable to the cooperative banks. And subsequent to this endorsement issued by the respondent bank, my lord, the Reserve Bank of India has issued the notifications. This part of the petition. Yes, I have, I may permit to rely upon the document also. Please, ma'am. Please, it is not. It is. My lord. In the my lord, with great respect, my lord. That's what we say. Withdraw it and explore whatever the possibilities you have. Explore it. Please, But if you ask us to decide it, we will decide in the manner we are expressing. please, my lord. For you to take it on. My humble submission is, my lord, I am filing the memo covering only these two things. I am seeking the permission of this honorable court to approach the respondent bank with only these two contentions. One, so far as the OTS is concerned, my lord. We are clear. My lord, otherwise I will. Not in this case, not with this background. My lord, with great respect, my lord. Let them make their stand clear by today evening also. Let them, Okay. my lord. Otherwise, I will approach them, my lord, because if they make their stand clear, whether they are giving certain concession before this honorable court itself, my lord. One submissions I like. We have told you.
Please.
My lord, Why go there? We say nothing. I will withdraw the writ petition, reserving liberty to urge these contentions before them, my lord. And I have complied with the interim order granted by this honorable court. Sale is not it. If you want to withdraw this will be withdrawn. You want to go there. Then again, keep- the second round of litigation would start. Please. My lord, if I am not wrong, I had two options, my lord. Either directly approach the respondent bank after seeking permission to withdraw the writ petition. Or in second option is, I will make a request to the respondent bank, let them make their clear stand before this honorable court within 1 or 2 days. That would also be serve the very purpose, my lord. And Not in this. with great respect, I leave it to the discretion of this honorable court under 226, my lord. Please. You can at the most say this. You will say that you are, petition to close the bank. You will say, we say nothing, this is withdrawn. There is no opinion of us. Okay, we are recording. Recording these two. So regarding OTS and this total. We say nothing. We are only recording that you want to go to the bank. We say nothing, this will be withdrawn. Let them consider, without giving scope for any unreasonableness or arbitrariness, let them fairly with open mind. And I am withdrawing, no issues, I am withdrawing. With the signature of the petitioner who is present before the honorable court. Who is the petitioner? Petitioner's daughter is, petitioner's daughter is. Takes instruction.
Yes.
Consider this case. Everything has to be seen the facts, not in this factual. We will be harsh in our this thing. Not in this.
And only my this thing.
Seeks to withdraw the petition to enable the petitioner to say nothing on the submission. We can answer for the petitioner, except dismissing the petition as withdrawn. Okay.
My lord, with great respect, my lord, technicalities involved will be, they will say that you have urged all the contentions before the honorable court, and all those, this writ petition came to be dismissed, all those things. And at least.
You take a call. We are not saying that this is what, you take a call, whatever.
My lord, I shall, my lord, I shall be obliged, my lord, grateful. My lord was pleased to consider the fact that the bank is required to consider my request in the factual and legal. Let them consider, my lord, so that let it not come in their way, my lord. Ultimately, my humble.
We will not say so. We are clear. How many orders passed? How many times you have been given? How many times you have been sent to the bank? How many times the bank has been asked to accept the money? And how many times you have failed to give the money? Tell us. Not in every fact we can intervene. Not in this fact, surely, yes. In a given case, yes. We don't want to be so.
My lord, till date, so per the whether I'm entitled.
Okay, thank you. On this order or not?
Ma'am, I have the instruction from the client. I conveyed the message to what my lordship has conveyed yesterday also, my lord. In fact, only this submission.
We are retaining this order which we have passed.
Yes.
We want to withdraw it to approach the bank. We say nothing, that this petition is dismissed as withdrawn.
Dispose.
Make any difference?
This may kindly be disposed.
Dispose of as withdrawn. That will help you. Say all the rest. Oh, thank you.
24
Grateful
urgent,
for the opportunity.
24 urgent, 25 Shri Ram.
I represent petitioner in this matter, my lord.
the order which is under challenge. Next year, page number 24. The facts leading to the matter is, I am the owner of survey number 8/1 and 8/20. No notice. That is all the grievance. Respondent number 2, your lordship. My lord, at page number 30, para number 3, impugned order. Notice of these proceedings were issued to the writ petitioners for their appearance before this committee. Notices sent twice through register post to the address mentioned in the writ petition were returned unserved. An opportunity that I am seeking at the hands of this honorable court. I will appear before the authority, and an opportunity is given, I will make out my case. Will Lordship kindly say, I am the owner of the property and I have made an application before the authority for denotification. When they did not consider my application for I filed a writ petition. There was the direction by this honorable court, by the learned single judge of this honorable court. Committee. The matter was referred to the committee. The committee, though issued notice, it has not been served on me. I have no knowledge about the proceedings. Therefore, an opportunity may be given.
Who appears who has been given direction to file the objections?
Lordship, it's a report by respondent number 3. The respondent number 3 is a committee constituted by the order of this honorable court, your lord.
But last time they were directed to file response. This is to respondent number 2.
This one is not served on third one.
No, this is to, in the meanwhile, counsel for respondent number 2 to file response. Last order says.
Yes, yes.
Response number 2 is.
Notice.
Yes, sir.
You file your response.
It's a committee report. I cannot make any comment on the committee's report.
Committee has considered certain aspects.
Yes, sir.
Either you will say that you concur with those aspects because they refer to the Supreme Court, what are the guidelines?
No, I concur with the committee. Whatever it says, I concur with them. Only thing is, they are seeking an opportunity. It may be remanded only with a subject for providing an opportunity. Apart from that, I cannot make any comment on the committee's report.
Yes.
Your Lordship, kindly say. There is a report by the committee. May I request this honorable court to come down to para number 17 of the appeal memorandum, writ petition. On all the 4 sides, the land has not been acquired. Admittedly, no notice was served on me. On all the 4 sides of the property in Your Lordship, kindly say.
The whole case is you are running an education institution.
Yes.
There is a finding of fact against you that education institution has come afterwards based on your own communications. You say you are in agriculture, you are doing agriculture. Is that ground?
I purchased.
If you were present, you would have argued this.
Yes, my lord.
What is this?
Your Lordship, kindly say. The application of Bondu Ramaswamy case has not been taken into consideration by the committee. On all the 4 sides of my property, there is no acquisition. It is only a, yes, there is no acquisition.
For the respondent number 2 states, no response is required to be filed. This statement is taken on the part. The counsel for the party shall file the written submissions along with the judgment they want to rely upon. You are here for whom?
For respondent number 1 and 3.
1 and 3 also. Well, you have nothing, no role.
Actually, I wanted to file a statement of objection in this case law. So because notice is served to that other suspect, kindly see law in page number 30.
When was it show us? Which page?
Page number 30, Lord, in page number 30, para number 3. 330. 30. 30. Married Lord, para number 3.
Yes.
Notice of these proceedings were issued to the writ petitioners for their appearance before the commission. No notice was sent twice through the registered post to the addresses mentioned in the writ petition were returned unserved. An attempt was also made to serve notice for these proceedings to the writ petitioners to the advocate, who represented them before the Honorable High Court. However, the notice was sent to the advocate with the registered post. That is also returned unserved as addresses left. In view of the fact that the notice of this proceeding sent to the addresses furnished in this first title of the writ petition, and since they were returned unserved, this service of notice on the writ petition was treated as deemed to have been served on them, and therefore the committee proceeded with the consideration of the matter.
Yes.
1411. Number 26. Shaditya.
For the petitioner. The petitioner in this case is challenging the cognizance order taken by the land grabbing court, my lord, with respect to the petitioner's property, my lord. The petitioner is challenging the impugned order, my lord, is at page number 104, my lord. In the impugned order,
This case, not very short question is involved. The amendment of section 2 is applicable or not. You know, I'm not yet seeking the report from the Tahsildar of the concerned one. Actually has already filed a report before that land gap court. Based upon that, not the court is not accepted the version of that other side. Therefore, not I pay for another vacation. 10 days more.
my lord, one submission. Not one submission. My lord. Till then, I've sought for an interim prayer seeking for stay of further proceedings before the land grabbing court. My lord. Same may be allowed. Please.
He says it was beyond your limits.
Please, my lord.
Need the date before the land grabbing.
6th of November, my lord. November, my lord. 2020.
So we have it before that.
Please, my lord.
Okay.
Please.
The counsel for the you appear for. I appear for complaint, third respondent, my lord. Have anything to say on this?
No.
See, he says the very complaint is not being maintained because. The amendment act, my lord. What do you say? My lord, there is a conflicting report submitted in the petitioner's annexures, my lord. One is that is beyond 3 kilometers, another within 3 kilometers, my lord. That is the report submitted, my lord. One is by the Tahsildar and another by the PWD, my lord.
My simple explanation for this is there's an app called Dishank app, my lord. Through that, they have ascertained that it falls less than 3 kilometers. The very opening of the app says that this is not fit for legal use, my lord. And subsequently, the second report has been submitted.
We'll ask for that.
Please.
But he will determine this.
Yes, ma'am. Please.
See further time of 2 weeks to pay. Yeah, 3 weeks. Yes, 3 weeks. I think request is given in October.
Lord, a date may be fixed, ma'am.
2410.
Please.
Sir, 2410.
Please, 2410. Much obliged.
27.
I'm for the petition. I pay for the response. Yes. Lord, I've been asked.
First petition is of very narrow compass, my lord, short matter. The issue involved is, first petition is 19009 of 24. The issue involved is, my lord, similar to 56J, the Indian Railway IREC 1802A is applied, where they say that your services are terminated as compulsory retirement in public interest. Annexure A1 may kindly be seen, my lord, page number 70. This is the simpliciter order, not punitive. And that is the emphasis laid down by the Honorable Apex Court interpreting such provisions. Based on that Supreme Court decision, they have formed master guidelines. Even they admit unconditionally that yes, it is not punitive. Their stand in the reply also is consistent, it is not punitive. Therefore, my lord, when the order do not say it's not punitive,
can they, the question of law involved here is, my lord, can they deny me the benefits flowing from that order of compulsory retirement, which is simpliciter, like commutation and gratuity, as on the date of my termination, when there is no charge sheet or cognizance is taken? That's the simple issue, my lord. In fact, yes, indeed, there was 2 FIRs. Now, law that they invoke is, there are only 2 provisions of law, my lord, that they can invoke. Rule 9 of railway pension rules and Rule 10. My humble submission is, before taking my lord's kind attention to that, my simple answer is Rule 9 and 10 is not available to them because it is not the stage, it is premature. That comes into picture only in such judicial proceeding if I am found guilty of grave misconduct. Therefore, kindly say annexure A4, my lord, for
Proceedings go on.
my lord, that is why Honorable Supreme Court in Kandaswamy clearly says the discretion of the Honorable President under 310 cannot be subjected to Article 309, which is statutory rules. So 310 and 311 take precedence over 309.
We are governed by the statutory rules. You have to.
My lord, here.
This is not in accordance with statutory rules.
My lord, here, that's why, my lord, I will mention that issue, whether which should prevail, comes in the next petition. Just to give a brief introduction, my lord. Here is a case where the Honorable President of India decides, though they have powers under 309 to keep me under suspension or continue with departmental inquiry, they decide to exercise powers of the Honorable President, which says, we simply terminate your services, saying in the public interest, we don't require your services. The punishment, though it is simpliciter, my lord, I incur a huge punishment of curtailment of my 6 to 7 years of service. But however, that is one punishment. In fact, the very circular and Supreme Court judgment says, such simpliciter termination should not be as a shortcut to an inquiry. So the intention being noble, they cannot, my lord, initiate that also and say you undergo one more inquiry, that is double jeopardy. Nah. They want to, on the same FIR, they want to now initiate one more inquiry. That's why, my lord, kindly see page 84. I'll clarify this aspect. Page 84, annexure A4. When they issue me that public interest termination, I claim certain benefits, commutation and other thing to be released because it do not come in the way, it is not punitive, it is not stigmatic, it is not to punish, it is not to haunt. Kindly see the reply they have given, my lord. Page 84. Subject, your representation for release of commutation and regular pension. So and so. In response to your representation, it is intimated that as per my CEO so and so, Hyderabad has registered a case under RC 19A 2018. They refer to this particular FIR, my lord, dated 31/12/2018 against you while working as Sikandrabad before joining SCR, and case is still pending against you. They say FIR and say pending. As per so and so 10 sub rule C, gratuity shall not be paid to a railway servant. Now the question is, let us see if 10C really interprets the way the respondents have interpreted it.
May make one submission. If your lordship may kindly turn to page 68 of the petition, my lord, for a moment. I'm sorry, sir.
No problem, sir, please. 68.
68.
Where?
Kindly see his prayer, my lord. My learned friend has accepted the order.
I'm not challenging it. That's my stand also
Therefore-
before this court.
Therefore, this is only with regard to the
Commutation.
and
Exactly. That's my case. I'm not
if your
challenging.
lordship may kindly turn to page 207 now. The other day I pointed out, my lord, this is the benefits given to him. Page 207, certificate. Your lordship got it, my lord. This is the amount of 1 crore 3 lakhs which is received, my lord. This is the retirement benefits.
No, that is provident fund.
Provident
Let them
fund,
not say that.
all-
That's
all
my
that-
saving.
that I'm not disputing it. If your lordship may kindly see 4, encashment of leave on average pay, that is also paid. What is withheld is gratuity and commutation value. For that, my lord, the other day, my lord, your lordship asked me, what is the complaint? Complaint in 9. Rule 9, my lord. For that, my lord, if your lordship may kindly, madam, the CRPC, the definition of a complaint, if it is seen, my lord. And for that, my lord, my learned friend has to challenge it before the criminal court, not before this court, whether a complaint prima facie, there is a complaint. Please.
Either complaint or report.
Police report. What is the complaint? There's a complaint as of now. If your lordship may kindly see 2D, my lord, complaint.
Complaint 2D means allegation.
Taking action under this code, that some person, whether known or unknown, has committed an offense but does not include the police report. A report made by the police officer in case which discloses after investigation the commission of non-cognizable offense shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to have been complaint. Here, my lord, it says the FIR is by the police officer on the source information. Your lordship had directed me to verify whether is there a complaint. My lord, my instructions are that, my lord, on the source of information, the FIR is registered. So therefore, my lord, now, if your lordship may kindly see the interim prayer, what is sought in this petition for a moment.
I have not sought any interim prayer.
Interim prayer is at page 35 in the first petition.
I'm sorry, stay off here.
Indian category. But not either. President taken to 29. ಇದನ್ನ ಕೇಳಿಲ್ಲ ಅದು ಕೇಳ್ತೀವಿ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ
But once the source is the basis for that FIR,
please.
How will that source give you the information? It's not a complaint.
It's not a complaint.
That's it. But what is 154 contemplates is given an oral.
Please.
An oral.
Lord, that the stage. Therefore, the cognizance is not taken yet, my lord. That has to reveal, my lord.
Complaint or report. A complaint which may not have resulted in a report is also sufficient to stop the retirement benefits. Is sufficient.
Please.
See, the intent of rule 9 there is if these two eventually complaint or report are there, that means the pendency of judicial proceedings.
That is what last occasion I.
No benefits.
No.
That's the. So, report, it is not a case of report. Report which has been taken cognizance, that is what is contemplated is a charge sheet.
Please.
Report under 173 resulting in the filing of. But here they have used the word
Complaint.
What do you mean by word complaint? Complaint is merely, for registering an FIR, I am giving you writing saying that
it's
there is a cognizable offense. But here it is a case of source. So it is not a case of a written complaint. But 154 contemplates even an oral. Is it an order?
Lord, according to the FIR, my lord, your lordship may kindly turn to, my lord, page 71. 73 is the, my lord, which starts, my lord, reliable information has been, may I read it out? Page 73. My lord. Lord, now my learned friend apprehension is this, my lord. The court also pointed out whether his defense can be put out. Whether there is defense in the DP and in the judicial. Your lordship may direct us to defer the DP for some time till the evidence is led in the judicial proceeding. Till then, my lord, now according to the table, my lord, at page 73. No. He is getting a provisional pension in my compilation, my lord, page 12. I'm sorry, page 12. But he is getting 1,45,000. If commutation is that, my lord, he'll get 1,06,000. The lump sum. Therefore, my lord, till the judicial proceedings, till the evidence is led in the judicial proceedings, your lordship may direct us to defer the disciplinary proceedings, my lord.
Lord, prayer before the tribunal, like. Kindly, my lord.
Lord, your lordship may turn to page 68 in the first petition, my lord, 19009.
Like my learned friend submitted, I do concede fairly. I did not challenge this order of Honorable President at all. Honorable President in the public, yes, ma'am. I made to Honorable President in his letter said you can address a letter to me if you want to find out some reasons or some query. I did submit 2 representatives. Please. Commutation. I'll demonstrate, my lord. I will just, that's why, my lord, in the beginning I said it's a narrow compass. However, my friend wants to. I'll justify just 2 minutes, my lord. But unfortunately that it was sought to be expanded, horizon sought to be expanded. Kindly come to 84, my lord. Case is so, my lord. Point is, now an order is passed, which is settled law, which says that I would not suffer any monetary consequence because of this public interest compulsory retirement. That is the law, which is also followed by them admittedly, unconditionally. Then I sought for the grant of the benefit that arises from that order or flows from that order. I made representations. In response to my representation, they issue a reply. That is at page 84. That is the only document I'm relying upon. They say, we cannot grant you the commutation and gratuity for the simple reason that then FIR is filed and case is pending against you. Now, there are 2 things. They invoke Rule 10(1)(c) of pension rules. So all along, they can be quoting only 2 rules to deny me my legitimate benefits. That is Rule 9 and Rule 10. Now, Rule 9 has 3 portions. Rule 9 clearly says the President has absolute right either to withhold or withdraw pension or gratuity when only if a pensioner is found grave guilty of misconduct in a judicial or a departmental case. As that stage arrived, answer is no. So can they invoke that? Page 58, my lord. I've extracted that page 58, my lord, of the first petition. May I read it, my lord? Rule 9. Right of the President to withhold or withdraw pension and or gratuity. The President reserves to himself the right of withholding or withdrawing a pension or gratuity or both, either in full or in part, whether permanently or for a specified period, and of ordering recovery from a pension or gratuity of the whole or part of any pecuniary loss caused to the railway
if in any departmental or judicial proceedings, the pensioner is found guilty of grave misconduct or negligence. Proviso of, my lord? The next, my lord, per 9(5)(b), my lord, next page. Kindly see page 59. That is one option, my lord, if I am found guilty. Now, how do we understand whether on the date on which the statement of charges is issued, on that day, no charges. They issued after 3 years. Now, what is relevant is B. B, my lord, judicial proceedings shall be deemed to be instituted in the case of criminal proceedings on the date on which the complaint or report of a police officer of which the magistrate takes cognizance is made. Now, this rule clearly, unambiguously lays down the position. Either there should be a complaint or a police report, that is charge sheet, of which cognizance should have been taken. That is the date on which. My lord, in check bounce cases,
Complaint.
See, what will be said is this rule. We should repeat that in case of criminal proceedings, on the date on which complaint or report of a police officer or the magistrate take cognizance is made. But in both the eventualities of a complaint and a report, the cognizance need to be taken by the magistrate. Mere filing of an FIR would not suffice.
At least.
So, these FIRs were pending on the date when he was compulsorily retired. Okay. But the cognizance was not taken on the date of retirement. You getting the point? If that is not taken, when will you pay the commutation? On the date of retirement. When was he retired? Maybe he had retired through compulsory retirement. That is the time when you will give him commutation.
and gratuity.
And gratuity.
Got it.
That's my case, my lord. When you cannot establish institution, you cannot go to the question of pending. Pendency is an even subsequent institution. When according to law, when there is no case instituted, how can you deny me right?
What is mean this provisions have been instructed, provided that.
My lord, dishonorable court's recent order I have produced, my lord. Page number 12, interpreting the same provision, this honorable court held as on that date there was no cognizance, therefore you cannot deny. Clear, there is no doubt.
That's the point. We want to see, we want to see some judgments on this.
Please. Supreme Court also, there is one judgment, my lord, which clearly says on the point. I'm sorry. On the,
You see, now, can merely a pendency of an FIR is sufficient? The rule doesn't say so. That means FIR means, see, what are the FIR means everything. But what they say is that the magistrate applies his mind and take cognizance, then only there is some credence to the charges which have been framed against him. Then only you will.
Good. That's the gray area, my lord, where settled position. In one not gray. Given that on the date of the complaint or report, the department should institute it on the date on which the statement is.
The FIR is supposed to be based on DH, based on DH report. Please, what is the DH report? Where is the DH report? That can be treated as a complaint. Now,
See now, the cognizance what is of the report only, not complaint. We'll tell you why. See, complaint is the first step. That results in investigation, result in filing of the charge sheet, resulting in the cognizance taken by the magistrate. If that is the action which is contemplated by a complaint, you don't require a complaint. So see the two extremes. Even complaint would suffice, but the other extreme is cognizance by the magistrate.
Correct.
So that means from the first stage to the last stage, anything which falls will get covered. Is that the intention, or a complaint or a report of which a taken? So that means cognizance is of both or only of the report. See, you may have to look into this. Otherwise, because we will be holding the law for across the board. This would govern all future cases.
And the interpretation of 9. Whether it is the date of the retirement,
whether a complaint or report of which cognizance taken.
Correct.
You can argue, and he will argue what? You can argue complaint is sufficient. Because what is contemplated for cognizance is of the report, not of the complaint. But he will argue that complaint is sufficient, the cognizance is only of the report. Just look into it, we want to see.
Not 2D. 2D refers to 200.
PCR.
Only 150.
Correct.
Just say that, just the request of the council, the parties. Yeah, the request of Mr. Bhutan, Deputy Solicitor General of India. When do you want? We'll have it post the Congress. There's new date post.
2810.
My lord, meanwhile, like my, please. Yes, my lord. On 7 to 8 grounds, my lord, solid judicial grounds, I have challenged it.
The next petition.
Yes, my lord, that is the next. Worry at all, because it's a simplicity.
Then you ask, the common mother, the motion submits as the date of hearing is what is the date?
27th February, I've placed the copy, my lord. This month, my lord. I've got one more copy.
A request shall be made to the inquiry officer to defer the proceedings to a date beyond the date fixed by this court. See, we don't know on what grounds you are challenging. Let us know what are the grounds you are challenging.
First ground is, my lord, in terms of Article 310, cannot be, my lord, both are mutually exclusive. That is one thing. Second thing is, my lord, the charge memo is not approved by the disciplinary authority. And third ground is, disciplinary authority asked me to reply. I have asked for an oral hearing, which he offered me, but he has not passed any order on that.
Right, you say they have not issued by the disciplinary authority.
There is no approval of the charge memo, which is necessary ingredient in terms of the Honorable Supreme Court. Because minister has issued the letter, not the president.
And it's the sanction of the president. I just point it out. It's a sanction of the president.
Minister only.
My lord, that is
Discharges in rupees under that.
Allocation.
Transaction of business goods.
Allocation.
My lord, in this case, even minister has not approved. They have admitted that fact before the tribunal. It is not their case that it is approved by the president of India. If that is established, I have no case, my lord. But they have admitted.
Minister has approved, that's a compliance.
Minister has not approved, my lord. Railway board has issued it.
I just point it out.
That is why, my lord. And the other ground is, my lords,
In the-
that
Who has approved it?
Railway board. I'm not disputing.
We will see. We will just get it right.
I'm not disputing it, madam. Sanction is there, but that is why Supreme Court says sanction and approval of charge memo are two distinct things which has to be exercised. Because president is discharging statutory duty, not executive duty. Therefore, he is bound. What is preferred in statute has to be performed in the same manner it is proposed, not. Please.
Approval comes when he is in working of the charge sheet, when he is working. Sanction will come, sanction to proceed under the line of the pension rules.
My lord, in Rajendra Singh, the very same contention as is taken, is answered. Till such time, no inquiry to be. Grateful, much. Much obliged, grateful,
7/11,
much obliged.
7/11, 29, Venkatesh Kumar.
For the petition. The last occasion, my lord, your lordships directed me to refer to a judgment passed by your lordships. I have got the judgment, my lord.
Sir, 29, sir.
What is the issue?
MACP, that is grant of MACP under to RTA, this illustration 28. The yes, the judgment is there. My lord, it appears to be applicable.
Against you. Against you.
Yes, it appears to be against it.
Follow that.
But let it be said, my lord, I have not considered.
It is obvious.
Appear for respondent 1, my lord, in this.
Yes, it's identical. Lord.
I appear
Page
for
number,
respondent. my lord.
A1, page 33. I'm sorry. Page 11, my lord. Page 11. Page 12 is the order. I got it, my lord, in 2017 after 30 years. From the date of initial appointment. Well, about to 11, my lord, to 2011 is my prayer, because the promotion was given, first promotion was given to me on 2/11/1991. So I complete 20 years on 2/11/2011. My lord, my date of appointment is 21/8/1987 and promoted as HS2 on 2/11/1991. So I complete 20 years, my lord, from the date of first promotion on 2/11/2011.
When did you got it?
I got it, my lord, after 30 years of my appointment, that is 21/8/2017. Third MSc.
So you were claiming.
Yes. 1/8/19/2008, they have given me this.
But what was to be given?
My contention is after the 20 years completion of the first promotion. First promotion I get into 1991. 20 years from that date is my prayer.
3 years.
From 2/11/1991, which is the date of promotion.
So, 10 years.
20 years, because the first promotion, first MACP, they have given me when the date MACP came into effect. That is second MACP. So there.
March 2016, asked for the Secretary Administrative Court.
Dismissed. The OA is dismissed.
The petition before the tribunal was that whereas the petitioner had got the promotion on 25/11/1990. That's right.
Let 2/11/1991. Yes. No.
11/1991. With the post of
HS2. Yes.
is the benefit of third MACP
Yes.
must be from 2011.
Yes.
2011. The tribunal has dismissed the petition, not granted the review of the petition. We have in the petition number, the petitions, two petitions, being the 557. Consider the issue of draft of third MSC based on a clarification issue by the Union of India and stated as in paragraph 5 the other added. That be so from our grant of third MSCP shall be either on completion of 10 years of residency period.
19/2008.
19/2008. You want that was third MSCP or?
Yes, my lord. No, second MACP was given to me on 19/2008. My request for third MACP is from 2011, which is 20 years from first promotion. State parties.
2008, on which they speak of the benefit of second MSCP.
Yes.
Second MSCP. You need of the petitioner is to be accepted, then he would get third MSCP from
2/11/2011.
The instructions being clear and the instructions and our conclusion therefore said the petition being clear. We are afraid that the plea as not the petition cannot be accepted. It's not the away. It's not
Great. No, only the date of promotion is 15/6/1992. Therefore, he will get from and he becomes entitled, according to me, from 15/6/2012.
Next.
30. Number 30.
For the petition. Matter. Well, I take about an hour. I know.
You can give a short day. So if you want before vacation, you can give it.
Well, it can be after vacation. There is no such urgency, my lord. I must tell you, Lord. I'm sure my learned friend will agree. Well, just one. Yeah, my lord. He is entitled. He is entitled. I respect that. I respect that.
Or can it be taken after vacation, my lord? Because after vacation, my lord, your lordship may give a date, we'll come and answer.
See, we are right. We can, we wish there is a partial matter which we are reading, possibly we can utilize this time till lunch. And we have kept the other partner at 3 o'clock, so we'll have half an hour there. So we want to squeeze in at least, we will have it immediately after the holidays. You give us 14, 15, 16, whichever day convenient, we will give you.
My lord, may I request, my lord, subject to, of course, my learned friend agreeing now, my lord. My lord, any date after, any date after 21st May. Any date, subject to my learned friends. Convenient. Then I borrow that. My lord, what happens, my lord, is a few days after vacation, I'll not be here. 21st,
he says, will that be fine?
I'm not.
It's not possible today. We have two partners. And that's the reason we one matter which we have kept it at 3 o'clock also, that need to be heard. 3 o'clock. That's the reason. So 21 will suit you? No issue, not. Just re-notify on 21/10/2024.
21st, my lord.
21st.
Yes, will be.
Thank you.
Grateful.
31.
Yes, we'll have it some other day.
Good.
We notify.
24/10.
Day.
Store matters. 14. 14.
One more passed over matter, serial number 19, my lords, in which the service of notice was not completed. But I'm just filing a memo, my lords. Yes, just to file this memo, my lords. Lords, the service of notice is not completed. Last hearing date, your lordship suggested. Yes, I'm just filing a memo, my lords, which indicates there are two writ appeals. The appellants are respondents here and respondents are appellants here. And the other unserved respondents in this writ appeal are those who did not contest the proceedings before the learned single judge, which is reflected. I'm filing a memo to that effect. Lords, please, my lords, but appellants will have to, I'm sorry, I should have been on the other side. Yes, sorry, my lords.
Are these respondents who are still?
No, they don't have any subsisting interest in the properties.
No, we will, at your risk, we will say no discipline.
No, because appellants will have to say that, not say. I'm for the respondent.
Then I think, who is the appellant?
Binay.
Yes.
Yes, lords may note the memo, lords. I'll also serve a copy so that he can look into it and.
Which respondent?
Lords, third respondent in writ appeal 58 of 23. Please.
In both the appeals. Same shall be considered on the next day.
Please, lords. Any date, lords, in the second week, lords, after the commencement.
Yes,
Please.
Yeah. 24/10.
Lords, it's great.
Yes.
Yes, sir. 14.
From Mr.
14.
Now you will first come to section 8. Whatever in seriatim he has argued, just argue that. Who has given? Okay, yes. Is your mic on?
The auction proceedings of 21/1/2017, where the petitioners are said to have been the responsible officers, for the conducting of the auction, that is was a subject matter of various proceedings, including the one before the Honorable Lokayukta, by way of a complaint. It was the complaint was referred to for the purpose of conducting preliminary inquiry. The Deputy Commissioner and the Superintendent of Police would make a preliminary inquiry and submit a report to the Honorable Lokayukta. Based on that report, without naming anybody, the Honorable Lokayukta would recommend to the competent authority, that is the Government of Karnataka, to take certain steps. But that steps does not pinpoint a person and the pinpointed action against such a person. That kind of a, for the simple reason that the notices were not issued at the earlier stage. So my learned friend would complain before this Honorable Court that there is non-compliance of section 9(3), and there is the complaint itself could not have been received in view of the bar under section 8(1)(b). Is my learned friend's complaint before this Honorable Court. I have also placed judgments. My learned friend took my lords through various judgments of this Honorable Court, and also relied on the principles so far as the natural justice under section 9(3) is concerned. And what happens when a complaint in relation to section 8(1)(b) is received? That is the principally, my learned friend would rely on Gundappa's case, Yediyurappa's case, Kumaraswamy Minerals case, and fairly, my learned friend conceded while taking my lords through Kumaraswamy Minerals case that it is admittedly a bad law for the purpose of section 8(1)(b) and section 12(3). My learned friend was fair to concede that. Then Subindra Gumaste, next judgment also, my learned friend would say so. Then sixth judgment, Dharmasthala Manjunatheshwara, that is in relation to PIL, where this Honorable Court, according to my learned friend, a reading of that judgment, my learned friend would interpret to say that even a PIL is an alternate remedy. That is the item number 6. That judgment also relies on Kumaraswamy Minerals, which my learned friend has incidentally admitted to be not good law. Of course, I'm borrowing his words. He would say that it's not good law. I'm borrowing his words. Whether it is good law or not, my lords will consider. Then Fayaz Ahmad Sheikh case, my learned friend would place reliance on. That is item number 7 in his compilation, but he did not read through it. Myself and also my learned friend for the complainant, R6 and R7, would also rely on Fayaz Ahmad Sheikh case to say that Kumaraswamy Minerals case is not applicable to the facts of this case. Now, my lord, in my compilation that I have submitted to my lords.
This is your compilation?
Yes, my lord. In my compilation that I have submitted to my lords, I have the caption is short list of judgments in relation to section 9.
You also rely on Gundappa?
Yes, my lord. Gundappa. And, what I submitted, my lord, when I gave this.
Yes.
What I submitted, my lord, and I still stand by it, when I gave this list of judgments, none of this, my lord, referred to, my lord, section 12(1) report. None of this refers to a situation where there is no notice, my lord, before the issue of notice. None of this, my lord, refers to, except, my lord, item number 5 of the Honorable Supreme Court. Except item number 5, none of these judgments not refer to a situation
I've lost the video connection, man. Look, I've lost the video connection.
to A, it is not mandatory. So there is a distinction. So it's not that in all cases it is mandatory. Lord, coming to the judgment at serial number 5. That is where I had stopped. May I take my lords to serial number 5 judgment, my lord, page 36 to 30, it is a short judgment of the Honorable Supreme Court while dealing with, my lord, the AP Lokayukta Act case. Page 36. It refers to preliminary inquiry. Lord, it refers to a situation of a preliminary inquiry. Head note A, B, and C, all three of them. Right. May I take directly, my lords, to para 4. About 4-5 lines above para 4. Or rather, my lord, I'll read as para 3. Your lordships are at page 38. Para
That's
3.
right, we are.
Subsections 1 and 2 of section 7 give power to Lokayukta and Uplokayukta respectively to investigate into any action concerning persons respectively mentioned therein. Subsection 3 of section 7 enables Lokayukta, notwithstanding the power conferred under subsection 2 thereof on the Uplokayukta, to take suo motu action in respect of any action contemplated under the Act. Therefore, the only condition precedent required thereunder is to record reasons for initiating suo motu inquiry, divesting the power of the Uplokayukta, and taking action under subsection 3 of section 7 of the Act. It is next contended that the petitioner has not been given any opportunity before submitting the report to the government, and the action is contrary to section 10, read with section 12 of the Act. We find no force in the contention. The Lokayukta is empowered under the Act to conduct such preliminary verification as he deems fit, or proposes to conduct any investigation under the Act to find whether the allegation in the complaint prima facie justify for conducting regular investigation. Subsection 2A of section 10 postulates that every preliminary verification referred to in subsection 1 shall be conducted in private, and in particular the identity of the complainant and of the public servant affected by the said preliminary inquiry shall not be disclosed to the public or the press, whether before or during the preliminary verification. But every investigation referred to in subsection 1 shall be conducted in public. In other words, the statutory provision contemplates that while conducting preliminary verification of the complaint under subsection 1 of section 10, the investigation is required to be made in confidentiality, and on satisfying from the investigation of the alleged misconduct, etc., he is empowered to take further action under the Act. He is also empowered under section 11 to collect evidence or have the investigation done as a civil court by operation of subsection 2 of section 11 of the said Act, only when he satisfies that there is evidence to proceed further under section 10(1)(b). At that stage, he shall afford an opportunity to the aggrieved person to comment on such complaint of the statement and conduct the investigation or inquiry. He is enjoined to give reasonable opportunity to the public servant. After conducting this said inquiry, if he finds that the public servant or the person referred committed misconduct, then he is required to submit the report to the government as enjoined under section 12 of the Act. On receipt thereof, under subsection 3, it shall be lawful for the government to take action as recommended by the Lokayukta. Considered from the operational conspectus of the above provisions, it would not be necessary to issue any notice or give opportunity to a public servant at preliminary verification or investigation. When the Lokayukta or Uplokayukta, as the case may be, conducts a regular investigation into the complaint, it would be necessary to give prior opportunity to the public servant, etc. By implication, such an opportunity stands excluded when preliminary verification or investigation is conducted. The object appears to be that the preliminary investigation or verification is required to be done in confidentiality to get prima facie evidence, so that the needed evidence or material may not get suppressed or destroyed. It is seen from the report submitted by the Lokayukta that he has prima facie found that there are some allegations against the petitioner. We are not dealing with the nature of the allegations since the matters are yet to be investigated. Suffice it to state that the Lokayukta has power to submit a preliminary report to take further action so as to enable the Lokayukta to conduct further investigation. The power to submit final report with recommendation to take punitive or penal action includes power to submit interim report with recommendation to suspend an officer or to transfer him pending further investigation or the preliminary verification itself. The object of the recommendation is only to enable smooth inquiry or the investigation conducted without being hampered with hampered with by the persons concerned or to prevent an opportunity to tamper with the record or to destroy the record. Under these circumstances, we think that the Lokayukta was well justified in not issuing any notice or giving any opportunity to the petitioner at preliminary verification.
So this you are saying his argument that the report which has been given of the
Yes.
DSP and
Yes.
that should have been given to him.
No, that's not my learned friend's contention is copy of the complaint is not given, he has not been notified. That is the complaint.
Huh.
But what the Honorable Upalokayukta in this case has
While those officers doing any investigation, they are required, that's what the court says.
no.
How would
Further,
you, no, how
Yes.
would you translate this judgment in the facts of this case?
that's what in the facts of this case also a preliminary verification was conducted. For that also notice was not issued. The Honorable Supreme Court said it is in accordance with law. But there are a little confusing at page 307, the first 10 lines. There are two stages there. The first stage, their lordship say notice not required. Second stage, only if he decides to proceed further. But that confusion occurs here. Fifth line onwards, in other words, the statutory.
In other words,
the statutory provision contemplates that while conducting preliminary inquiry, preliminary verification of the complaint under subsection 1 of section 10, the investigation is required to be made in confidentiality. This ends the first stage in confidentiality. Then that conjunction and is there. That and will lead to the next stage. And on satisfying. So after this satisfaction comes, that investigation requires notice. I'll read now again. And on satisfying from the investigation of the alleged misconduct, etc., he is empowered to take further action under the Act. He is also empowered under section 11 to collect evidence or have the investigation done as civil court by operation of subsection 2 of section 11 of the Act, only when he satisfies that there is evidence to proceed further under section 10(1)(b). At that stage, he shall afford an opportunity. It says, similar that conjunction and that if we do not read it, that gives rise to some confusion. And what their lordships clearly say in this para 4 at page 307. Yes, there are two stages. One preliminary verification at that stage not required. 10(1)(b) they say. Thereafter, their lordships say that if he decides to go further, if he decides to record evidence.
Based on preliminary investigation, the evidence has come, then he will proceed.
If he comes to the satisfaction that it requires investigation, proceeding further, collection of evidence is required, then he will notify the respondent. That's what it says. And conclusion is clear. The first 3-4 lines of para 5 and the last 2-3 lines of para 5. The conclusion is clear.
Yes.
Then the next judgment, Professor S.N. Hegde. Judgment of the Honorable Single Judge of this Honorable where section 9 of the Lokayukta Act was under challenge. His lordship would come to the conclusion that section 9 is not ultra vires, it is in accordance with law. Then the fact that the petitioner therein was not a public servant was also not concluded by the Supreme Court, saying that the university, the professor working in the university is not listed as one of the public servants in 2 section. While holding those, while also not coming to the conclusion that section 9 is a code in itself, providing for filing of complaint, opportunity, conducting investigation, his lordship would, at para 91, would say, your lordship will come to para 91 in that judgment at page.
Yes, 110.
110. Page 91, his lordship would rely on Gundapa's case, and page para 92. I'll read para 92 carefully, slowly. A reading of section 9 of the Act makes it clear that the legislature took care to insist upon the observations of principles of natural justice even before Lokayukta decides to conduct an investigation under the Act, after making preliminary inquiry. If the intention was that, without hearing the public servant, the Lokayukta should not embark upon an investigation and took care to specifically provide for the observance of principles of natural justice as contained in section 9(3). It cannot be said that after satisfying the aforesaid provision, the Lokayukta is under no obligation to follow the principles of natural justice, while actually conducting an investigation into the complaint after the public servant offered his comments, denying the allegations made against him. The principles of natural justice and the necessities for its observance in any manner of investigation or inquiry is sine qua non of every judicial or quasi-judicial act. So, my lord, reading, my lord, any which way this para 92, it suggests, my lord, no doubt, it suggests not that natural justice has to be followed, but nobody is doubting that. But what 92 would also say that it is required to hold investigation. If it is required to hold investigation, you are putting him on notice. Then 9.3, his lordship would say that it cannot be said that after satisfying the aforesaid provision, the Lokayukta is under no obligation to follow the rules of principles of natural justice.
He has to follow. Then means he has to follow.
He has to follow, not 9.3.
9.3, at 9.3 stage.
Yes. 9.3, my lord, for a moment, if I, without my lord, requiring my lords to take the book, I'll just read it from 9.3, where the Lokayukta, Upalokayukta proposes after making such preliminary inquiry, it says. So 9.3 contemplates commencement of investigation by notifying.
So according to you, what has been done is only a preliminary investigation.
Yes, preliminary inquiry. A report is there. It has report has come forth, and recommendations are made. That recommendation do not crucify anybody. That recommendation do not hang anybody. That recommendation says initiate action in accordance with law. It only says so. Initiate action in accordance with law, recovery action if permissible, because under the Cooperative Societies Act, there is separate recovery action under section 70. Dispute to be raised, inquiry to be conducted, opportunity is there, not evidence, cross-examination, all opportunities are there, not the appointment of legal representation, opportunity is there. It contemplates not the Cooperative Societies Act. Then not disciplinary inquiry or placing the petitioner under suspension. None of these recommendations say place him under suspension. Recommendation says initiate disciplinary proceedings against erring officials. It says. So, erring officials, again, it is for the DRCS to Registrar of Cooperative Societies to first come to the conclusion that these are the erring officials. Thereafter, he will initiate, thereafter he will notify. And your lordship may kindly see the date sequence of dates itself. The 12.3 report is dated 1/3/2018, and the first step or the first action after the 12.3 report, my lord, is 1.5 years later. That is by issue of a notice. Annexure P is the 12.3 report, 1/3/2018. Then the first of the steps, my lord, appears to be only after 1.5 years, that is 16/5/2009. I'm sorry, I stand corrected. It's about 14 months. Annexure Q, 14 months. 16/5/2019. So, my lord, it cannot be said that yesterday 12.1 report was there and today action is initiated. That also is not there. Even the 12.1 report says Annexure Q at page 137. It is in Kannada, but the translation is also there. This notice, your lordship will see, show cause notice is issued to my lord, calling upon.
Yes.
Calling upon an explanation. Thereafter, again, 16/5/2019, Annexure Q1 is another show cause notice. I'm sorry, it is the reply of that person who was the noticee. Not Annexure Q is page 137. The translation, your lordship will see at page 139.
Yes.
This notice, my lord, is issued to Sri M. Dakshinamurthy. Then he would give a reply, my lord, at 16 Annexure Q1.
That's right.
At page 137. Thereafter, my lord, other proceedings are there.
This is the reply.
Annexure Q1 reply of It's not even the petitioner. Dakshinamurthy, my lord, is the
No, no.
notice there.
He's also the petitioner.
Sorry, he
He's
is the
also
second
petitioner number 2.
He's the
second petitioner.
Yeah.
Sorry, I stand correct. Annexure Q is the notice issued to second petitioner. His reply at Annexure Q1. He has submitted his reply. And then page 154, Annexure Q2. It is to the managing director, then so on and so forth. My lord. Proceedings are there. So, my lord, all the time requesting my lords to consider is that 12-1 report is just a preliminary report. It is a recommendation, not and it fulfills the requirement not of this judgment of the Honorable Apex Court in Ramrao versus Lokayak of 1996. But the other judgments, none of them are in relation to 12-1 report. None of them are in relation to preliminary inquiry, except not a passing reference at para 92.
Did you meet his argument on 12-1?
12-1, Lord. So, my lord, what I am respectfully submitting is this 12-1 report which is issued. Of course, the word investigation is there in 12-1. 12-1. If after investigation of any action involving a grievance has been made, the Lokayukta and Uplokaykta is satisfied that such action resulted in injustice or undue hardship to the complainant or to any other person, the Lokayukta or Uplokaykta shall by report in writing within 3 months at the event not related so and so, recommend to the competent authority concerned that such injustice or hardship shall be remedied or redressed in such manner and within such time as may be specified. 12-1. Though it uses the word investigation, I would respectfully submit, Lord, the judgment of the Honorable Supreme Court in Ramrao versus Lokayukta, Lord, at paragraph 5, their lordships would say that a report, a 12-1 report, would also include an interim report. May I request, Lord, for a moment, page 39.
But tell us one thing, when a preliminary investigation is held,
yes,
is under which provision?
But the moment this complaint is received,
comes,
yes,
then 12 will trigger.
But it will probably not trigger, Lord, because of the use of the word investigation.
That's right.
But I am also saved, Lord, by the judgment of the Honorable Supreme Court at page 39. It says, Lord, the power to issue a report also includes a power to issue interim report. Lord, page 39.
No, but would that mean that it is only to the extent of investigation, not preliminary?
Only to the extent of the preliminary findings and the opinion formed by the Honorable Uplokaykta at that stage.
Giving an opportunity to him, and then 12-1 report precedes an opportunity to the delinquent.
But if it is a further process after a preliminary stage, then it has to be, opportunity has to be granted.
Now, in this case, what happened?
In this case, we have not yet reached that stage, is my respectful submission.
Oh, but why do you say that report as a 12-1 report?
But it is captioned as a 12-1 report, not for want of any other provision. Not the only provision under which a report is submitted under the this legislation, not is either 12-1 or 12-3.
These are the only two.
Only two provisions under which not a report of this
First
nature.
thing, when a preliminary investigation is done,
Yes, yes.
will it be construed as a report or a?
But it could be treated. Your lordship could probably read it down as a preliminary inquiry report. That also is not if your lordship come to conclusion that 12-1 could not have been exercised at all. But the lordships of the Honorable Supreme Court say not preliminary report is required. It is required to be held in confidence. It is required to
right, Mr. Arbat.
Yes, yes.
Then you will only nomenclature it as a preliminary inquiry report.
Yes, yes.
But you will not say 12-1.
We could not have probably, yes, because of the use of the word investigation in 12-1.
Not even investigation.
Yes.
The moment you say 12-1,
yes.
What does it contemplate?
But it could have to be, notice has to be issued. Yes.
A report, notice has to be issued.
Yes. Yes.
If it is preliminary, you will say preliminary, leave it at that, saying that this is only preliminary, I am not required to. So
Yes.
that stage of 12-1 has not come.
Yes, Lord, because we have not issued notice. And blood, yes.
Tell us one thing.
Yes.
But 9(3) component, there are two components. One is preliminary inquiry investigation, and then conduct an investigation under this act.
Yes.
9(3).
Yes.
So what you say is even 9(3) is only to the extent of preliminary inquiry.
No. After preliminary.
Where the Loyakta proposes to make such preliminary inquiry as deemed fit to conduct any investigation under this act.
Not after. It says.
After making. Oh, I stand corrected.
So,
So this is the next step.
next step. I should have issued notice in the next step.
Next step.
If I make up my mind, if the Honorable Lokak comes to conclusion that investigation is required, then notice under 9(3) is required. At that stage, my lord, if we had, in the facts of this case, if the Honorable Lokak had decided to issue notice, you should have attached the complaint along with the notice. You should have attached the inquiry report of the.
Are you saying that stage has come?
But we have not come to that stage, is my response.
Now tell us one thing.
Yes.
If this stage has not come,
Yes.
then the stage under 12 has also not come.
But I would respectfully submit, not for want of better terminology, not for want of better terminology, the power to issue a report under section 12(1) in the nature of a report under 12(1) or 12(3) also includes a power to issue an interim report. If your lordships were to read.
Yes, let's put it this way.
Yes.
Possibly this is what you want to convey. There is a preliminary inquiry.
Yes.
It has not fructified in an investigation till now.
Yes. Perfectly. Yes, ma'am.
If it is not fructified as an investigation, there is no question of going to 12(1).
Yes, ma'am.
Even possibly, we don't know whether the mentioning of 12(1) was inadvertent or a conscious decision.
But I would not say inadvertent. I would say a conscious decision for the reason, Lord, the power to issue a report under 12(1), a final report, so to say, if at all it were to be a final report, also includes power to issue interim report. This paragraph not saves this report, the impugned
But
report.
tell us, Mr. Arbati, if there is a 12(1) report, which should not be preceded by an notice to him?
But if it is a final 12(1) report, I would say I would rather categorize it as an interim 12(1)
But
report.
then this, you have to construe the provisions of the act. Okay, construct the other. Then whether 12(1) contemplates a preliminary report.
But if 12(1) read with this para 5, 12(1) read with this para 5 of this judgment, but it does contemplate not an interim report.
But I don't know, that will be the working of the act. If you
Yes.
go in seriatim.
But I understand where my lords are interpreting, Lord, the manner in
If
which.
you
Yes.
see in seriatim,
Blood.
first step, second step, third step.
Yes.
The third provision
Is
would
section
be
12.
follow the second will follow the one.
But I agree, my lord. But para 5 says otherwise, slightly otherwise, if I may say, not request my lord to
We'll come
consider
back
that.
after lunch.
Very well.
Matter pertaining death by medical negligence, contempt petition, copy has been served on the other side.
What is that?
It's the case of death by medical negligence, Lord.
So what is the petition?
It's the contempt petition. Size-
Contempt is not here.
Pronouncement file, ಇದು.
My lord, may list of authorities, my lord, in respect of that.
In which matter?
That matter was reserved for judgment. My lord.
Okay, take it.
My lord, one matter, my lord, for tomorrow, my lord, it's a.
What is the matter? What is the
My lord, this
urgency?
is in respect of bifurcation of milk unions, my lord. Bifurcation order was withdrawn.
Is it our roster?
Yes, my lord.
Shows that, man.
It's a bifurcation order was passed, my lord, milk union, my lord. Bifurcation order was withdrawn, which was, writ petition was filed against that order, my lord. Now the withdrawal order, we are withdrawing, my lord. As per resolution passed, general body meeting was held. Resolution was passed to withdraw that withdrawal order, my lord.
So what is the effect on the appeal?
My lord, appeal will render infructuous. Writ petition itself render infructuous. My lord.
We'll have it on when do you want?
Tomorrow, my lord.
Tomorrow. You have informed the other side.
Yes, my lord, I saw copy.
Ma'am, take this. Come, Mr. Arbati.
I'm sorry, I didn't hear.
My apologies, my lords, for not being physically.
Judgment.
Sir, one ನಿಮಿಷ. Pronouncement, serial number 32.
We are of the view that the observation made by the tribunal which we have reproduced above are justified. We do not see any merit in the petition, hence the petition is dismissed. I'll sign. Yes.
Serial number 14.
My apologies, my lords, for not being physically present in the morning. My apologies for not being physically present.
No, the discretion is there. Don't render apology now. Yes, Mr. Arbati. Mr. Arbati, you have to just slightly, concentrate on that, what we are asking.
Yes, ma'am, I agree.
Could you, in seriatim, see, it's like this, going by you, this, 8, 12, 9.
I would put it slightly different, 7, 8, 9 and 12, or rather, if we,
But once 12, you are saying preliminary,
yes.
then that 12 is preceding 9.
Yes, what I would respectfully submit is, yes, the report is named as a 12-1 report. But your lordship may kindly see the purport of the report, the recommendations made in the report. Your lordships will agree with me, it cannot be a sweeping observation made about a particular report or a particular order. And moreover, I would also request my lords to look at it from a slightly different perspective. That it is not a judgment and decree of a civil court. That it is not an order passed by my lords. That it is, even though carefully I would use the word, after all, a report. Not an interim report, a report. Whether natural justice, whether issuing notice, whether calling for comments, do the strict rules that would apply for a different kind of a situation. This is one, on one hand, I have a report. On the other hand, I have a judgment and decree, or an order passed by my lords under 226, or any other such court proceedings. But the natural justice requirement is entirely different in each circumstance, each situation, even though not it is named as a 12-1 report. Not even if that is so, your lordship may probably also observe that even though it is named as a 12-1 report, it can be read down and read as a preliminary inquiry report. Or your lordship could say what their lordships of the Honorable Supreme Court have said, an interim report at para 5 of at page 39.
So if it was a 12-1 report,
Yes.
what would be that nature of that report?
12-1, my lord, it will require not the competent authority to take corrective steps.
Take
Corrective steps.
the consequence of that investigation, what steps need to be taken,
Yes, my lord.
which can be in the nature of?
Not correct. For example, my lord, if the government has lost not particular set of lands, forest lands, but there could be not encroachment of forest lands. But by a 12-1 report, that we could recommend that to take corrective action because it is an illegality. Yes.
But nothing of that sort happened.
But there is not yes, my lord, not to the relatable to a particular individual. But we have found, my lord, in the preliminary situation, we have found that the auction proceedings may not have been conducted fully correctly. We are not passing a decree. We are not passing a judgment. There is no such categorical observation.
Mr. Arbati, let's assume it's a preliminary inquiry.
Yes.
What would now follow?
But the respective competent authorities would take action in accordance with the respective statutes, which is, for instance, my lord, if recovery is required to be done under the Cooperative Societies Act, Section 70, if proceedings for disciplinary proceedings are to be initiated, it will be under the.
Let's see these observations.
Yes. Annexure P, my lord, page 122. It starts. And the relevant page at page 128. Relevant portion, Lord, at page 128. May I read,
But
Lord?
tell us one thing, is it not conclusive to do ABCD?
Lord, in relation to the findings there, Lord, it would still not be conclusive. It is a report. It is a recommendation. Your lordships are aware, not of the distinction between a report and a conclusion of an order, a conclusive nature of an order, a judgment and decree. I am not even going to a judgment and decree, Lord. For example, Lord, an order, an administrative order passed, Lord, by the government, or an order passed by the deputy commissioner, or Lord, a decision taken by a Tahsildar.
These directions have not been acted upon.
But some of these have been acted upon. Some
Like?
of these have been not
Like,
like the issue of the show cause notice, not the next document itself.
what
It is-
have been acted upon?
Not your lordship could see the second recommendation.
Okay.
Recommendation is made to
Disciplinary action.
disciplinary against all the erring officials who are responsible for conducting the auction sale.
Okay.
It says there, not annexure Q, page 137 is the show cause notice.
On one, any inquiry conducted?
Recommendation is made to conduct inquiry and investigation into formation of it and also the auction sale proceedings through.
That has been
COD.
conducted.
But that I think is the FIR registered. That has culminated in the DRCS giving a complaint to the jurisdictional police and they have registered FIR. Third one, Malima.
What is the date of filing writ petition?
2020, my lord. 14 July 2020.
This was on 18. No, this is 18 petition. 20 years. Okay.
And also, my lord, kindly see, my lord, the developments in between the date of the auction, the 12-1 report, and the filing of the writ petition and the interim order granted by my lords in this, by this honorable court, not in this writ petition. Between these dates, my lords, that there is a coordinate bench of this honorable court says, not directs the government, state government, not to consider the report. There is, my lord, other proceedings, my lord, challenging the auction proceedings, not in revision. It is there. I'm told, not it went back and forth. Interim order granted in the revision petition was challenged here, or rather not granted, was challenged here. Then matter was remanded. So, my lord, revision was dismissed. Again, challenged, my lord, matter was remanded. So, my lord, several of those proceedings are there. Between the date of the auction sale proceedings, then, my lord, the 12-1 report, then, my lord, this writ petition. Lord, these developments are there. Lord, I would not humbly request, my lords, to consider, Lord, if I am not able to convince my lords on the 12-1, the correctness of the steps taken by the Honorable Uplokayukta in issuing this 12-1 report, but I would request my lords to consider this, to read down the provision of section 12-1 from the caption and to treat this as a preliminary report. It does not crucify anybody in particular.
No?
It does not crucify anybody in particular. It does not name anybody. So, my lord,
How would the competent authority decide who is the hearing official?
but that it has to be on record. Only the annexure is the which
That is his he will decide.
he will decide. But it has not. Nobody has been named here. Even if my learned friends, what my learned friend read out, several paragraphs, not my learned friend read out. The respondents have done this. The respondents have done that. No, those observations are there in the report, in the body of the report. No doubt about that. But still, not a full-fledged inquiry, full-fledged opportunity is available to the petitioners.
But tell her, Mr. If it was a preliminary inquiry for you also,
Yes.
Lokayukta also.
Yes.
Ah,
Yes.
then there is further to be done by the Lokayukta before he could have given these directions.
It could have been. Yes. It could have been. That also.
Not a preliminary in that sense.
Blood, in this situation, it is preliminary. After this, my lord, as your lordship rightly said, we could have issued the notice ourselves, calling upon, my lord, them to respond to this. But we chose, the Honorable Uplokayukta at that time chose, my lord, to send the recommendations to the competent authority. And the competent authority has not, my lord, rushed to, my lord, take action. It has, the next step has taken about 14 months. And of course, my lord, in the meantime, there are several developments. That 14 months plus thereafter, and the judgment of the coordinate bench of this honorable court. And your lordship may also kindly observe, the judgment of the coordinate bench of this honorable court would say, in view of the above direction being a direction to the government to consider the 12-1 report, in view of the above direction, this PIL is disposed of, is what their lordships would say. So in that situation, your lordship may probably, not in the scenario that your lordship do not find not force in my respectful submissions, then your lordship could say that the 12-1 provision, in the caption can be not read down.
To mean?
To mean it is a preliminary report.
Then what follows? Same thing.
And legal consequences.
What are those?
Which is not the competent authority to take steps. What is recommended here, or they decide not to take steps.
So then what you are saying is this cannot be construed as a 12-1 report.
As yes, my lord, and also that is in the case that my lords are not convinced with my respectful submission. But I am seeking, lord, to take force under this para 5, page 39 of the judgment of the Honorable Supreme Court. The same, lord, the power to issue a report also includes a power to issue interim report. And the only provision under which I could have issued a report is 12-1 or 12-3. I have not gone to that stage. So, my lord, this has to be read as an interim report only.
But 12-1, if it is an interim report,
yes,
still a notice
After that stage, that is what we are saying, Lord. Recommendation is made to conduct an inquiry and investigation into the formation of so and so. Recommendation is made to take disciplinary action against all erring. Lord, all these require, your lordships are aware, all these require to conduct an inquiry, to conduct disciplinary action, all these require not issue of notice.
But not at the stage before the recommendations are given.
Lord, in this stage, yes. Need not have been because we have not named anybody here. And still not at.
But tell us one thing, Mr. Bhatti, this proposition, what you're advancing, that this must be treated as a preliminary report, maybe under 12.1, or may not be under 12.1.
It has to, yes, ma'am. Yes,
Huh?
yes, ma'am. Yes, ma'am. I'll answer.
It may not be under 12.1, but if it is under 12.1, one, it is construed as a preliminary report. And even for preliminary report, no show cause notice is required. Though otherwise, if a report under 12.1 is there is a show cause notice.
Yes. Yes, ma'am. If I were to say that these persons were responsible, take action against them, then your lordships, it flows from that principle. No doubt about it. We are not even, of course, not the complaint against two named designated officers, not by their personal names, but by the designation that they hold. But we do not even conduct an inquiry as to who was the sales officer at that time, who was the auction officer at that time, who was the section 441 officer at that time. That kind of an inquiry is not conducted.
That was not conducted.
That was not conducted. It is only a report given by the Deputy Commissioner and the joint and the Superintendent of Police jointly. That report is looked into, a prima facie report is prepared and sent to the competent authority with the 3 recommendations.
Because are we to say that these recommendations become relevant? No, these recommendation necessarily has to be given under 12.1, no.
No, need not be, need not.
Need
but
not.
but the only power to issue a report is either under 12.1 or under 12.3. And Honorable Supreme Court says the power to issue a report also includes power to issue an interim report. This has to be read as an interim report, is my respectful submission, is my request to my lords also. My lords, permit me, my lord, at the cost of repetition, I'll read para 5 once again of that judgment. Considering from the operational conspectus of the above provisions.
Yes.
Considering from the operational conspectus of the above provisions, it would be necessary to issue any notice or give opportunity to a public servant at the preliminary verification or investigation when the Lokayukta or Uplokayukta, as the case may be, conducts a regular investigation into complaint. It would be necessary to give prior opportunity to the public servant, etc. By implication, such an opportunity stands excluded when preliminary verification or investigation is conducted. The object appears to be that the preliminary investigation or verification is required to be done in confidentiality to get prima facie evidence, so that the needed evidence or material may not be got suppressed or destroyed. It is seen from the report submitted by the Lokayukta that he has prima facie found that there are some allegations against the petitioner. We are not dealing with the nature of the allegations since the matters are yet to be investigated. Suffice it to state that the Lokayukta has power to submit a preliminary report to take further action so as to enable the Lokayukta to conduct further investigation. The power to submit final report with recommendation to take punitive or penal action includes power to submit interim report with recommendation to suspend an office. Yes.
Tell us one thing.
Yes.
Let's assume you gave certain observations, made certain recommendations.
Yes.
Now, once these recommendations are acted upon, the matter will not come back to Lokayukta now.
But we have not even sought, but it was open. Yes. Yes, it will not come back.
It will not come back.
It will not come back.
How is it preliminary then yours?
But it will not come back in the sense, Lord, we have, Lord, in 12.1 report, your lordship will see, we will make recommendations. Then under 12.2, the statutory obligation is on the competent authority to report back what has been done.
But there is no, it's only for your information.
Yes, it could be.
So so this, so even though it's a preliminary, see what preliminary submits, and that's what Supreme Court says so. Pending further investigation.
Yes.
By whom? By Lokayukta.
Yeah.
But here that stage will not come because Lokayukta
yes.
has put it on the competent authority.
Put it to the competent authority, yes.
So it will not come to you.
But
So
it need not.
In that sense, it's a final report for you.
I would, yes, my lord, I would respectfully submit it need not come back to us. It is for the government also to decide whether to send it back to us.
Okay.
The government could have said, my lord, in relation to the first recommendation, conduct investigation in relation to, my lord, to send, it could have sent it back to, my lord, Lokayukta. I have a police wing, I have an inquiry wing, I have an administrative wing. The government could have sent it back to in relation to the first recommendation. The FIR which was registered by the jurisdictional police could have very well been registered by the police wing, not in the Lokayukta itself. Not all the time seeking Lord's consideration at this stage, in the facts of this case.
My lord is right. This recommendation is for final, for an action on the part of the competent authority.
Yes, no. It could have been sent back also, is what I am respectfully submitting. The competent authority could have said, yes, we accept your recommendation, you please conduct the inquiry. That could have been done by the competent.
That's only at his behest. But insofar you are concerned, that is out of your bounds. Once you have taken a call to competent authority, do this ABC.
Yes, my lord, that your lordship could observe that also. It could be.
No. What we are saying is,
Yes.
So we are only now deliberating whether this is a preliminary report, as you say, or it is has the trappings of a final report. According to us, it has the trappings of a final report because the Lokayukta has sent it to the competent authority to do it and then take action. With an intention, it will not come back. That's a different issue. The competent authority says, we have seen it, you do it at your end.
Yes.
That's another thing.
Yes.
Suppose the competent authority said, okay, you have said it, I will do it at my end. So to that extent, it becomes a final report.
It could be read like that, but there's nothing to suggest that it is a final report.
No, see, no, very well, nothing to suggest. But what is final report? One which attains finality, not an interim measure.
Yes.
It attains a finality. Now tell us one thing. If it was actually a 12-1 report, let's assume that's your contention. It is not a 12-1 report. It is a 12-1 report. The recommendation would be in the same manner, can be in the same manner.
But it could be in the same manner. Yes. So for that purpose, I'll read 12-1 for a moment. Last 3 lines of 12-1. What can be done in a 12-1 report?
So ultimately, we have to construe the provisions of the act.
Not very well. I am not faced with the only issue of use of the term investigation in 12-1. If investigation in 12-1 was not there, because 9.3 says if you would decide to conduct investigation, then issue notice. 9.3 says. 12.1 says if after investigation you come to a conclusion that there is injustice or undue hardship, then you recommend action, is what 12.1 says. So 12.1 contemplates investigation, which is issue of notice, 9.3. But there cannot be any 2 thoughts on that. But in the reading of this, does not disclose that it is in the nature of a report or a recommendation naming a particular person. It says there is, yes.
Not naming a person cannot be construed as a main report or final report.
But again, the terms back and forth can be used.
Say so. We will say so. Why?
Yes. Yes.
Here you have not named.
Yes.
You say, I will not name it, but I will give a report to the competent authority for him to do the investigation and then conclude the erring officials.
Yes.
And identify the erring official and then take action.
Yes.
To that extent, it becomes final for you.
Yes.
I will not take
yes, but I will not
give it to the competent authority.
But I will not mince words. This is what it is. Yes.
This is what it is.
Yes. This is what it is.
So then the short question would be 9 need to be followed
or not.
then the necessary consequence is, then it is a final report, not a preliminary. If it is not a preliminary, if it is a final report, 9 was to be followed.
Yes, my lord. If it is a final report, 9(3) has to be followed. Yes.
Then the other effects, what he was arguing.
Yes. Then if your lordships were to not find fault with the report on the ground of non-issue of notice, then not the consequences. Again, your lordship may have to. Recommendation is made disciplinary.
See, if you see, Mr. Arbati, the para 5, the Supreme Court.
Yes.
We are not dealing with the nature of, just see, you got that line. It says, I think 10th line from the bottom, we are not dealing with the nature of allegations since the matter are yet to be investigated. Suffice it to state the allegations that Lokayukta has power to submit a preliminary report or take further action so as to enable Lokayukta to conduct further review. The next line is important. The power to submit final report with recommendation to take penal or punitive or penal action includes power to submit interim report with recommendation to suspend an officer or transfer pending further investigation or even smoothing conducted without being hampered. See, the intent is, I do preliminary, I give preliminary directions, suspend him, transfer him. God, you have to do final investigation. Where punitive or penal action is recommended. So the distinction drawn by the Supreme Court is, what is the effect of a preliminary report? Yes.
In fact, my lords, in the Andhra Act, the scheme of the Andhra Act is very different, my lords. Section 9 and Section 10 of the Andhra Act is completely Section 9 of our state act, my lord. Now, the Andhra Act uses the word verification. My lords, if I may hand over the Andhra Act, my lords, because
Okay, we'll come to that. No, let's assume, let's draw whatever you are relying upon this. The Supreme Court draws a distinction. What is the purpose of preliminary report? It's only to ensure, based on this preliminary, A, B, C are the officers, suspend them, transfer them. Because you have to do the final investigation. It's like a suspension under the service jurisprudence.
Yes.
But when it comes to final report, it is the punitive or penal in nature against such officers, saying that this is the conclusion against them.
Yes.
But here, the directions are not in the nature of a preliminary report. The directions are actually, this is what we want to know, are these directions without, though you may be right in saying that no officer has been named. No officer has been identified. So, it is not punitive or penal qua ABC.
Yes.
Unlike what is contemplated here. So, to that extent, it is preliminary. But what if ABC are identified, then possibly what you are saying is we are in agreement in the sense it is still a preliminary because no one has been named.
Yes.
And ultimately left it to the competent authority, whosoever has done what you identify, do it.
Yes.
We will stop here because we have that 3 o'clock matter. We have to hear that matter. Are you arguing? Do you intend to argue? Assuming for a moment the court doesn't agree. This is what possibly you wanted to argue also. what is the consequence of that, or what is the effect of that, you which possibly want to argue?
Yes. Yes, my lord. My lord, natural justice, my lord, cannot be in thin air. Somebody has to complain natural justice. My lord, this recommendation does not, my lord, directly hit the petitioner. In any of these recommendations, it does not name them. My lord, trying to, my lord, take from my lord's.
What would happen to the action which has been taken till now?
My lord, that is why I am requesting, my lord, in the facts of this case, your lordship may.
So you wants to argue that what would be the effect?
Lord, this.
We want to hear that also.
Very well, I will. I will not. I will try to place.
Who appears for the state? No, who has to take all these actions?
Not the state. We always not invariably send it only to the state.
The state has to take action.
But thereafter, the state decides whether it has to take action or it has to send to the
Have they
registrar.
filed any response?
Reply.
You should take instruction, update instructions. What have been action taken pursuant to the report? You want
But
to
they-
understand
yes.
that?
Next matter.
Okay, we will have it. See, we can have it only post vacation. We can't have it before that. Don't have time. Just say that we are hearing.
Clarification, my lord.
Pardon?
That our application seeking clarification. my lord.
That we look into it. Just hold on. We are.
No.
Just say we have further heard Mr. Arbati for the respondent number
1.
1 to come up for his arguments.
Not
on
R, 3 minutes. R2 and R3.
R2, R3. Mr. Ravindranath. Mr. Ravindranath, you will take instructions. What are the instructions you have after this report has come? You may not be having it now, Mr. Arbati,
No, ma'am.
because you have done your job.
We sent, along with the covering letter, we sent the whole file.
Okay, date, just give the date, ma'am, whatever is convenient, around in October only. Interim order, if any. Huh?
That's good. Could I also request if it can come up under the further hearing caption?
We have said so, whatever we have said.
Sir, 2210.
Call that matter, the other matter. And can you call it? Any model is there? Just ask him to come. That we want to hear from you, Mr. Arbati
Yes.
and Mr. Ravindra.
Yes, ma'am.
What is the?
Yes, ma'am.
Call the.
Seal number 33.
ಕಾಪಿ ಅವರಿಗೆ ಕೊಟ್ರ ಅವ್ರ ಮುಂತಿಗೆ ಕೊಡಿ. Remove this. Yeah, here. This.
Yes.
My lords, may I start?
Before my learned friend starts, once again,
Yes,
my lord, other day, I was directed to file the synopsis, e-synopsis, and also legal submission. E-synopsis is already filed, my lord. Legal submission, I am presenting it now. Very short quotes. I have served the copy.
that's, yes, ma'am.
My
You can
lords.
continue.
Please. My lords, on the last date of hearing, we had completed reading the inquiry report of the Deputy Commissioner, my lords. The impugned order, my lords, is at Annexure A.
Yes,
Annexure A, my lords, is the impugned order before the learned single judge, by which it is declared as a institution under section 42 and 43 of the Act. My lords will get the translated copy from page 49.
yes,
My lords. This is the order of the government declaring it under section 42, my lords, on 10/3/2022. May I read it, my lords? My lords, Annexure A. Subject, regarding the declaring Shri Urukateshwari Amma Temple of Ummattur village, Chamrajnagar Taluk as notified body by the government and taking custody of the same. Letter bearing so and so, dated 14/12/2019. My lords, this was what read out. Page 49, my lords. Annexure A,
just one.
my lords. In the letter written by the Commissioner Religious Endowment Department, we had informed that the villages from all communities from the village had held several protests for declaring Shri Urukateshwari Amma Temple of so-and-so district by the government as notified body, and thereafter taking into its custody, and had in this regard had submitted several requests. Therefore, he had submitted an opinion in order to maintain the communal harmony, and in the interest of public, it will be very important that Shri Urukateshwari Amma Temple of Ummattur village, Chamrajnagar district, be handed over to the Religious Endowment Department. There is a case bearing MFA number so-and-so pending before the Honorable High Court. Therefore, the Honorable Deputy Commissioner had recommended that by considering the fact that of the unfortunate incident that had taken place in Shri Kitchengutti Maramma Temple, it appears appropriate for the government to take into the custody Shri Urukateshwari Amma Temple, Ummattur village. Accordingly, it has been prima facie evident at facial appearance that Shri Urukateshwari Amma Temple, Chamrajnagar district is being mismanaged, and therefore a show cause notice was sent to the President of the Temple Trust as to submit a reply within a month with regard to the fact that as to why the government cannot take it to custody and the said temple under the provisions of section 42-43 of the Act, to which he had submitted a reply by giving reasons for the objections as to why Shri Urukateshwari Amma Temple should not be taken by the government into custody. Therefore, it was requested to the Honorable Deputy Commissioner to conduct an inquiry proceedings according to the rules provided under the provisions of section 46(6) of the Act, and objections were sent, and thereafter to submit a report. Accordingly, the Honorable Deputy Commissioner had served notices to Shri Kitchengutti Maramma Temple and had conducted an inquiry proceedings under provision of section 43 of the Act, Rules 2002, with regard to the taking of custody by the government on 30/8/21. On 6/9/21, I had submitted a report with the following proposal under the provision of so and so. But declaring Urukateshwari Amma Temple as a notified body by the government and thereafter taking into its custody. Shri Urukateshwari Amma Temple, Chamrajnagar district is a very old and has ancient in nature and is having its own traditions, customs and importance, and the devotees from various places including from Mandya, Chamrajnagar, Bangalore district and even far off from Tamil Nadu are coming to visit this temple. The opposite party had submitted the judgment copy of the order passed by the lower court with respect of ownership in charge of Sri Urkateshwari Amma Temple. From the copy of the judgment in case bearing number so-and-so, it is evident that in all these three cases mentioned above, temple belongs to Lingayat community of Umattur village, and from thereafter till now, period from 1952-53 to 2014, no dispute has arisen within regarding to the ownership and maintenance of the temple, and according no cases or suits have been filed. It is to be noted in the year 2014, when a trust was formed by some people, therefore, maintenance of the temple, and as a result, a communal violence and misunderstanding took place. Even various suits were filed. As a result of this, there was disturbing in peace in the society over there. Furthermore, it is to be noted that during period 1952-53 to 2014, the Lingayat community did not have any claim with regard to the ownership of the said temple, and that during the period, the people from all communities, they would conduct festival of the village deity together. And now in the year 2014, when a trust was formed by some people, these people are claiming that they belong to the Lingayat community, and therefore they have a right to claim the ownership over the said temple, which does not appear to be correct. The very purpose of formation of the trust, after the lapse of 6 decades itself, raising the suspicion, and also that there are totally 15 persons there who claim to be the members of the trust. However, there is no sufficient proof to show that they represent the entire Lingayat community of the village. From the records, it's observed that the members of the trust have failed to gain the confidence of the people belonging to Lingayat community and other community of the village. And many complaints have been received from people that the trust is not taking care of the temple management effectively, and prima facie it's clearly visible. The legal points and opinion of public with regard to the tradition, customs, and other rituals followed therein by Sri Urkateshwari Amma Temple has been thoroughly considered, and the devotees of the village as well as other places visit the temple and offer to their devotion. When the deciding factor related to the cases of religious institution, it appears very important that not just the legal points must be considered, but it's very important that even the opinion of the people with regard to the tradition, customs, and other rituals followed are to be considered. It is to be carefully noted with regard to the point that when the car procession of Sri Urkateshwari Amma takes place, 19 different communities living in the village devotedly offer their service. This fact itself is enough to show the religious peace and harmony that exist among villages. Therefore, accordingly, the Commissioner of the Department has recommended that as per the proposal of the Honorable Deputy Commissioner, Sri Urkateshwari Amma Temple has been declared to be notified body by the government and thereafter taking into custody under Section 42 of the Act. Accordingly, the proposal submitted by the Commissioner Religious Endowment Department is thoroughly been verified, and following orders are passed hereinafter below. My lords, may kindly mark this word thoroughly be verified, my lords. And now the order. On the verification of the facts stated therein, the proposal, Sri Urkateshwari Amma Temple, Chamrajnagar district, has been declared as notified body by the government under the provision of Section 42-43 of the Act. My lords, this is the impugned order. Now may I request my lords to look into the impugned order, my lords, passed by the learned single judge. My lords, it starts at page 16. The operative portion, my lords, the observation starts from para 12 and para 13.
Yes.
Heard learned counsels, married, my lords, para 12, page 20. Heard learned counsels for the petitioners, respondent 5 to 13, and learned additional government advocate for respondent. Respondent 2 has issued show cause notice and annexure F under Section 43(1) of the Act. The petitioners have preferred objections and written submissions. Respondent 3 is the authorized officer to conduct inquiry into the objections, which is in compliance of Section 43(6) of the Act at Annexure H. Respondent 3 has submitted report on 15/9/21 Annexure B. Respondent 2, in terms of Section 43(7) of the Act, has submitted a report to the government recommending declaring of the petitioner number 1 as declared institution under Section 42 of the Act. Respondent number 1, acting on the recommendation of Respondent 2, has declared petition number 1 as declared institution under Section 42 of the Act. In view of the above, my lords may kindly mark these 4 lines. In view of the above, the procedure contemplated under Section 43 of the Act has been followed. In the circumstances, the contention of the petitioner that the procedure under Section 43 of the Act has not been followed cannot be accepted and the same is rejected. My lords, the learned single judge comes to the conclusion that Section 43 has been complied. My lords, the next para, Section 42 of the Act. Section 42 of the Act mandates the state government to declare an institution under Chapter 8 of the Act on being satisfied with the report of the Commissioner of Section 43 of the Act. As seen from the impugned order Annexure A, Respondent number 1, except reiterating the conclusion arrived at by the inquiry officer, that is Respondent number 3, and except making reference to the extent that recommendation of the Commissioner has been thoroughly examined, no satisfaction has been recorded on the report of the Commissioner submitted under Section 43 of the Act to declare the institution and the Chapter 8 of the Act. On the basis of the report, Respondent number 3 and recommendation of Respondent number 2 and 1 has recorded to its satisfaction to arrive at the conclusion for the purpose of Section 42 of the Act. Mere reference to the inquiry report of Respondent number 3 and recommendation of Respondent number 2 and conclusion, Section 42 of the Act is a borrowed opinion. The order declaring the institution under Chapter 8 by the Respondent number 1 is without recording satisfaction under Section 42 of the Act and without application of the mind. For the above reasons, the impugned Annexure A cannot be sustained. This is the first reasoning, my lords, for quashing the order. The second reasoning, my lords, para 15. Respondent 3 in his inquiry report has referred to various aspects with regard to litigation between the parties from 1944 to 53 up to 2014. The inquiry report further places undisputed up to 2014, my lords, the last paragraph. Respondent 3 has not recorded any finding as to how the creation of the trust after the lapse of 69 years results in mismanagement of the temple. In the same report, contradicting all other reasons, Respondent 3 records a finding that there is a religious peace and harmony being maintained while conducting so-and-so, conducting the Utsav consisting of 19 communities. The above finding by the inquiry officer is an appreciation of peace and harmony being maintained by the residents of the villages while performing jatra activities. The entire dispute has arisen due to the complaint lodged by Respondent 5 to 13 with reference to the mismanagement of the trust. The trust deed, Annexure J, depicts it's a public charitable trust and having various charitable activities. The total number of trustees declared in 15 in number. The Respondent 5 to 13 have any dispute against the trust. Section 92 of CPC provides the accrued person to institute suit before the principal judge. Next, para 17, my lords. The third line. It is not open for the Respondent 3 to record any findings on the correctness or the manner in which the trust has been created, its composition and activities when the same is registered, and the remedies to redress the grievance is provided under Section 92 of CPC. Respondent 5 to 13 have statutory remedy under Section 92 of CPC to approach the civil court. My lords, now I request my lords to turn to para 3 of the judgment. That exercise was done. In the facts, my lords, para 3. In page 21. Petitioner number 1, trust is a registered through registered deed dated so-and-so. Shri Puttanna and others filed an application under Section 92A of CPC in Miss 9 of 14, seeking permission to file a suit against petition number 1. The Principal District and Session Judge Shamraj Nagar rejected the said application dated so-and-so. Aggrieved by the order dated so-and-so, MFA was preferred. The appeal also came to be dismissed as withdrawn. My lords, only on 2 grounds, learned single judge, my lords, that there is no satisfaction recorded by the government while declaring it as a notified institution, and petitioners have to approach the civil court for dissolving of the trust. My lords, the main argument of the state is the Honorable Single Judge comes to the conclusion the entire procedure is followed. As it was read out to my lords, Chapter 8, the procedure for declaring Section 42 and 43 was completely read out to my lord. The learned single judge does not find fault with the procedure adopted under 43. The only difficulty learned single judge expresses in the judgment is we have not expressed the satisfaction. My lords, the order was read out to my lords. There is, in fact, in Kannada, my lords, if I'll just point out that particular word for satisfaction. Annexure A, my lords. ಆಯುಕ್ತರು ಧರ್ಮದತ್ತಿ ಇಲಾಖೆ ಇವರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. So they have analyzed and understood and then passed an order. So the satisfaction which is required under section 42, what is being referred to, my lords, has happened in this case. Only after the satisfaction, the order has been passed. My lords, only to buttress my argument, my lords. And the mismanagement, my lords, is glaring in the report where they say that there has been 15 people suddenly take over an ancient temple and start managing the affairs of the temple, and the villagers are not permitted to take care. My lords, this Religious and Charitable Institution Act, my lords, it's a special enactment. And my lords, I have produced a judgment along with my synopsis wherein the act was questioned and the act was upheld. I'll just read few paragraphs, my lords. What is the object behind the act, if my lords may permit? The synopsis I have placed on record both by e-copy and hard copy, my lords. My lords, B.M. Sukumar Shetty versus State of Karnataka, page 53, the running page, my lords, will get in the last judgment. Page 53, my lords. The object of the enactment is, I'll just read it out, my lords. Order. May I read, my lords? Page 55, it starts. India is a land of religions and temples. The Anthropological Survey of India published the series of People India describing the Indian society, culture, and traditions. Some of the main conclusions of the survey is as under. Ours is one of the most diverse countries in the world. There are 4,635 ethnic communities in our country, each with its own hereditary features, language, dress, religion, custom, food habits, family relations, and marriage rights. The basic lifestyle of these communities comprise the mainstream of lives in our country's people. The people of India have emerged from miscegenation of several races like Proto-Australoid, Paleo-Mediterranean, Caucasoid, Negroid, Mongoloid. Various nationalistic involved are Aryans, Persians, Greeks, Huns, Arabs, Turks, Africans, Mongolians, and Europeans. There has been so much intermingling that nowhere can one find a pure specimen of any nationality. It has been observed the difference in color, height, and build and other hereditary features are much more pronounced between members of the same community as compared to those between members of different communities. One of the biggest sources of our diverse and unity is language. There are about 325 languages and 25 scripts in India. These have emerged from different language families like Indo-Aryan, Tibetan, Burmese, Indo-European, Dravidian, Austro-Asiatic, Andamanese, and Indo-Aryan. Overall, 65% of our people are bilingual and practically all tribal people are trilingual. The use of two languages on a wide scale has led to better contact among different peoples, enhancing social cultural intercourse. The people of India have not lived in isolation from each other. They had a close connection with their natural and social environs. And for centuries, they have participated in each other's lives and struggles. It is this historical mutuality and collective struggles that have molded the shape of our diverse as well as our unity. Jawaharlal Nehru wrote in his Discovery of India, despite racial, religious, and linguistic differences or diversity, the life of Indian people is connected to single cultural spirit. The whole population of North India, despite some limitations arising from differences in caste or religion, believes in similar moral values and social customs, speaks the same language, has a common behavioral nature, which has been nurtured by a long history of their collective labor, suffering, and common struggle.
Just come to
Para 6, my lords.
Para 8.
Please. May I just read para 6 and come to 8, my lords?
No, that para 8 talks about constitution, enactment of this act,
Please.
purpose, objective, then
Please.
we will get it.
Please, my lords. 17 years after the above observation of Supreme Court, may I read, my lord?
Yes.
Para 8, my lords. 17 years after the above observation, Supreme Court, the government of Karnataka enacted Karnataka Hindu Religious Charitable Endowments Act 1997. The validity of this act and rules made then are called in question in these writ petitions, and also the quash the notification issued by the respondents in Section 23 of the Act. In the alternative, it is prayed to declare certain provisions in the impugned act are unconstitutional. It is necessary to refer briefly the salient provisions of the impugned act. The preamble of the act states that to make better provisions of management and administration of Hindu religious institutions, charitable endowments of Karnataka, comprehensive act is enacted by the Karnataka state legislature. There are 11 chapters, 79 sections. Section 1 of the state of the act is extended to the entire state of Karnataka and to the Hindu religious institutions charitable notified by state of government. The act shall not apply to mutt or temple attached thereto. The institutions run or managed by Hindu religious denomination.
14.
Please.
Para 14.
Section 42 to 48 of Chapter 8 of the Act deals with the power of the state government to declare and to subject to any Hindu religious institution when it is being mismanaged to regulation of this chapter. This is to be done by issuing a show cause notice to such institution and after holding an inquiry. Once such declaration is issued, the management of such institution vests in the state government, and the commissioner is empowered to appoint an executive officer. Section 49 to 62 in the chapter 9 of the Act deals with the powers and functions of the commissioner and other officers of the Act. The commissioner shall have the power to issue directions to the institutions to ensure proper administration and the account of income. The commissioner of the deputy commissioner, either suo moto or on the receipt of the complaint, may empower to institute to hold inquiries with regard to the institutions generally or any particular purpose. Take action against the persons to protect the property of institution from being wasted, damaged, alienated, removed, or disposed of. The commissioner has the power to suspend and remove or dismiss a chairman, manager, or any other person responsible for managing the affairs of the institution under certain circumstances and after following the procedure. May I just read para 6 now, my lords? The richer the endowment, the greater the temptation to swallow the same. When it comes to accounting for its income, the person in the temple started claiming exclusive rights of ownership, not only over the income, but over the idol, the deity of the temple too. Such instances justified the intervention of the local government. The proper maintenance of the temples and the administration of their endowments have always been considered in India as the primary function of the state. Under Hindu rule, the Rajas by issuing, so these are the main things. But the religious institutions with large revenues were often dealt with by trustees without due sense of responsibilities, and the mismanagements prevailed without check or restraint, and misappropriation of temple funds became a thing of frequent occurrence. The evil grew from bad to worse. This necessitated the enactment of several acts governing the management of the temples. So this is one of the main objectives, my lords, to make sure that there is no mismanagement and misuse. My respectful submission is, my lords, we have followed the procedure. We have given them the notice, their replies are considered. And this is a very popular temple, my lords, and it requires the intervention of the state because of this mismanagement by this 15 people who called themselves suddenly the trustees and took over the temple. And there is a huge law and order problem also in the village, my lords. That is the reason all these actions were taken. Learned single judge, considering the procedure is proper, only that the satisfaction is not completely forthcoming is what that would be incorrect, because we have on satisfaction passed this order under Section 42 would be my respectful submission.
Okay.
Please.
Mr. Ravishankar, you are also appearing.
Lords, I was also one of the respondents, Lords, in the writ petition who opposed the writ petition. But apart from
who opposed the writ petition?
Lords, pardon, Lords.
Who opposed the writ petition?
Opposed the writ petition. Now the writ petitions has been allowed.
Opposed the writ petition, you are taking stand akin to the state government.
Yes, but something else to add, Lords, because on the jurisdictional issue, Lords, the scheme of this Religious and Charitable Endowments Act recognizes two types of institutions. Lords, we have a long history. Lords, we had earlier enactments which were basically Madras enactments, 1927 Act. These were the institutions which were notified under those acts and brought within the purview of the government's management.
There were earlier it was called as the Mujrai department, now it's called as the endowment department. So we have this history that there were so many public temples. But essentially, it is on the yardstick as to whether the management of the temple or the temple itself is a public temple. That's essentially how it is. It was the yardstick. Now, whichever were the notified temples, essentially were the notified temples when the present act came. Other than that, Section 23 provided for a procedure that all these temples will be called as notified temples. Now, there were other public temples which were not notified temples.
What is the difference?
No, the difference is that there were the notifications which were earlier issued where it had already been brought within the management of the Mujrai department. So these notifications were already in place and they were already called as the Mujrai temples. So now there were several other ancient temples which were in fact not brought within the purview of the Mujrai department for various reasons, because there were no notification.
And managed privately.
But they were managed privately. There were various ways in which it was being managed. There were some hereditary administrators who are managing the affairs of the temple. So many other forms were there. This was a gray area. How to regulate, because there are various temples in our state which are public temples managed by private parties, in the sense that there is no governmental control. This was the gray area. There were several litigations which had cropped up in the past, where in respect of these institutions, either Section 92 suit is filed, or there are several declaration suits filed. So many other problems arose, but government did not have any control over them because there was no provision under the Erstwhile Act. So the legislature in its wisdom thought, other than the temples which is brought within the purview of the notified temples under Section 23 of the Act, there is another category of temple that wherever there are other public temples which is under private management, even those temples can be brought within the purview of the Act to be regulated in terms of the provisions of the Act, which is called as declared institutions. So we are having two types of temples. One is the notified temples or the notified institutions, and declared institutions. Notified temples, your lordships may kindly have a look at the provisions of the Act, Section 23, where it makes a difference.
We are concerned with notified temples.
We are concerned with the declared institutions. Just to draw out, Milords, as to why this provision is there. There is a human objective with which this provision is inserted. Because to say that by the learned single judge saying that no, 42, 43 is virtually redundant because you go on to Section 92. These were all what was considered when this provision itself has been inserted, 42 and 43. Lordships may kindly see Section 23.
At least what we have understood is there are public temples, but in the hands of private people.
Yes.
And which is the next one?
Notified temples.
Notified temples.
Yes.
Notified temples, when the Act came into effect.
There were already notifications. There was also an authorization to notify other temples. Therefore, I am requesting your lordships to take Section 23. The state government shall, as soon as may be after the commencement of this Act, publish by notification in respect of each revenue district a list of charitable institutions and Hindu religious charitable institutions which on the date of commencement of this Act are in the sole charge of the state government under the provisions of the 1927 Act. Sorry, Milords.
Yes.
So what were all the notified institutions? So all the existing temples which were under the Mujrai department were all brought within the purview of notified institutions. Let's page Section 23. The state government shall, as soon as may be after the commencement of this Act, publish by notification in respect of each revenue district a list of all charitable institutions and Hindu religious institutions which on the date of commencement of this Act are in the sole charge of the state government under the provisions of the Mysore Religious and Charitable Institutions Act 1927, or for the benefit of which a monthly or annual grant in perpetuity is made from the public revenues. Thus, the allowance under Section 19 of the Mysore Religious and Charitable Norms Abolition Act is paid. Then 2, religious institutions registered under the Book of Endowments of the Hyderabad Endowments Regulations, all institutions governed by the Madras Hindu Religious Endowments Act of 1951, all institutions of Kodagu district which are governed by the Kurk Temple Funds Management Act, all Hindu religious institutions registered under the Bombay Public Trust Act of 1950, all religious institutions which are in receipt of any monthly or annual grant from the public revenue or account They will have a two-tier system of control. There will be a Dharamdarshi committee which will be appointed, and there will be a control which will be depending on the nature of the temple. There are A, B, C categories of temples. So there will be a designated officer in the nature of Tahsildar or an assistant commissioner or a district officer. And then the commissioner will be there who is in charge of all these temples under the erstwhile 1927 Act. So this was the scheme of the Act. So all those properties, all those temples are brought within the purview of notified temples. So there is no difficulty. Now, in so far as notified temples is concerned, your lordships will find this, there are different and distinct way of management under chapter 4 and chapter 6 and chapter 7.
Chapter 6 is under which provision? Before
Chapter 6 under the same Act, section 23 to section 34 deals with the control exercisable by various authorities in respect of a notified institution. And chapter 7 deals with the budget of notified institutions, accounts, audit, etc. Now, this is the nature of control. That means notified institutions are concerned. There is a separate mechanism, separate procedure. Authorities are distinct. Mode and manner in which the management and the budget, audit and accounting takes place is completely different. So this is one aspect of the matter. Then that other gray area which was there earlier, that is what was sought to be addressed by inserting what is called as declared institutions under chapter 8. Now, declared institutions, your lordships may kindly take section 42. The state government may.
Yes.
The state government may, where it is satisfied on a report of the commissioner under section 43 or otherwise, that any Hindi religious institution, whether or not governed by a settled scheme, is mismanaged, declare such institution to be subjected to the regulation of this chapter, provided no such declaration shall be made without following the procedure hereinafter specified. That is section 43 procedure. Now, section 43, my lords, I will not trouble your lordships by reading section 43. Lordships may kindly come to section 44.
Yes.
Where any Hindu religious institution is declared under section 42, committee of management of the institution by whatever name called shall from the date of such declaration stand dissolved, and its administration shall vest in the state government to be regulated in the manner hereinafter provided. Then there will be an appointment of an executive officer for this temple under section 45. Term of office of executive officer is provided in section 46. Then section 48. Application of provisions of chapter 6 and chapter 7 in certain cases. Not all provisions are brought in by means of incorporation. Only certain provisions are brought in by means of incorporation. Now, the reason why this provision is there is to ensure that wherever there are public temples which are in the hands of the private management is mismanaged, then it is necessary for the government to take over its management and regulate or to manage the affairs of the temple in accordance with the provisions of this act to the limited extent, my lords, what
this chapter doesn't apply to notified.
Lord, this chapter doesn't apply to notified temples. Notified temples is like automatically it is
Government.
There. Yes, government. But so far as declared institution is concerned, is more like an expropriatory exercise where management will have no control of the temple. No management is the proprietor of a temple. They will be having some managerial interest, lords, in the conducting the affairs of the temple. They are lords, to explain.
Running.
Yes, that's all, running day-to-day affairs, but nothing more than that. They don't stand on any higher footing. So now these are the people who will be displaced, and the state government steps in saying that we are going to manage the affairs of the temple. The act itself is such that the entire customs, whatever is required to be followed, everything is safeguarded, under the provisions of this act. Now, so far as the present temple is concerned, the management which comes into existence, this is where the problem lies. The management which comes into existence is not identified by anyone. By customarily or by practice or whatever reason, a group of 15 people had gathered together and they said that we are managing the affairs. It's like, because I come from a rural background, we have two temples. There are 2-3 elders who are like in charge of the affairs of the temple. They only regulate it. There is no written understanding as to why they are managing the affairs. That is how it happens. In every village, this is how it happens. The elders are given their due credence, or because of their standing or social status in the society, they are given due credence. Or there are at times because of caste superiority, in a given society, they are given a credence. These things are there in our state. This is belonging to old Mysore state, where this practice has been there, that elders will be. Now, these people eventually happen to belong to one particular caste or a community. So they said, no, this temple belongs to this community. We want to manage it as per the manner in which we want this temple to be managed, and we don't want this temple to be handled by anybody else. But so this is the nature and tenor with which they started managing the affairs, and that is how the trust came into existence. So complaints were given, by these very respondents. We are also the complainants when the original complaint was given to the Deputy Commissioner. Then Deputy Commissioner started inquiring, at which point of time we filed a public interest litigation, saying that they are not taking any action. In the public interest litigation, the coordinate bench said, taking note of the fact, but by then Section 43 inquiry had already been initiated, directed that Section 43 inquiry should be concluded in accordance with law and expeditiously. So we were again relegated back and we came and participated in the proceedings. Now, in the proceedings, the Deputy Commissioner records a finding 1, 2, 3, 4, 5, 6, saying that this is a very ancient temple. There are so many devotees. Devotees is not from a particular class. And one thing I want to tell members, you can't give a caste to the god. You can't give a caste even to the management. Every person is entitled to it. It is not even restricted. That's the beauty of this Hindu religion, that any person is entitled to worship. So they wanted to come before the Deputy Commissioner and they filed their objection saying that, no, we have been managing these affairs. This is purely a Lingayat temple. I will read out from the objection statement. Deputy Commissioner said, no, this cannot be done. Every person is entitled to. This is a public temple. There are devotees of all kinds. Let them come and participate. So therefore, it's a fit case where we will have to appoint. Mismanagement is not in the sense of financial mismanagement. Mismanagement is in the sense of not permitting the devotees or claiming exclusivity of the nature of performances of the ceremonies in the temple by excluding others. This is essentially where the entire dispute arose. So therefore, my lords, the Deputy Commissioner said for 1, 2, 3, 4, 5, 6 reasons, it is recommended it should be declared as a declared institution. The Endowment Commissioner issued them a notice which is not under dispute. They submitted the reply, and Endowment Commissioner also said that I am satisfied with this report and mismanagement, and therefore I am declaring this as a declared institution. When that is challenged before the learned single judge in a certiorari jurisdiction, if learned single judge felt that there should have been subjective satisfaction in terms of Section 43, and which is not forthcoming, at best the single judge could have relegated the matter to the authority. Because it was not the ground raised in a writ petition saying that Section 43 or Section 42 is a provision which stands superseded by Section 92, and Section 92 says CPC remedy is such that 42, 43 becomes redundant. That is nobody's case, and it can't be somebody's case also. That was nobody's case. While exercising certiorari jurisdiction, two options. The learned single judge may say, on the basis of these materials, the authority should not have taken this decision, or on the basis of these materials, this is what I find is a decision which could have been taken by the authority. Only two things. In the event he takes the first decision, that the sufficient reasonings are not given per se in the order itself, the only manner in which it could be dealt is by remanding the matter. There is no way single judge could have relegated us saying that you go and work out your remedy under a Section 92 suit of a trust. Trust, all these things will not come at all. Now how Section 92, let's may kindly take Section 92. What Section 92 deals with? To interpret Section 92 as overreaching the human objective in respect of public temples under the private management being taken over as a declared institution for mismanagement, this is completely linked to an absurd.
But was the intent, see, ultimately why the impugned action was the differences between two sets of people.
The difference is between one set of people from a particular community.
Very well.
And the entire of the other community. There are 19 communities, 19 castes who are living in that village.
So that's right, but who had come forward? Who is opposing each other?
No, it's
Who were
all
opposing?
the 18 communities in one side and one community on the other side. Kindly have a look at the statement of objections filed by them before the deputy commissioner. I just take your lordships to page number 140.
So you say that it is not a 92 issue.
It's not a 92 issue. Let's assuming, my lords, that the learned single judge wanted, that should have been the pleading. Kindly have a look at the writ petition. That's not the pleading. Page number 50, my lords. 50 grounds.
Then give me the CPC. Which page you said?
Lords, 50, my lords. That is the grounds raised in the writ petition.
You said 50.
50. Lords, I'm sorry, Lords. I'm referring to page 50 of the writ appeal papers.
Writ appeal.
Yes, my lords. Page 50 of the writ appeal papers. That's not the ground. That's not the ground raised either before the deputy commissioner or before the endowment commissioner that your jurisdiction is barred because of section 92.
But because they were exercising under 42, 43.
Yes. But if the learned single judge order is to be addressed, my lords, it should be based on some materials.
No, but was it with an intent? Because there were two
Section
groups.
92, your lordships may kindly see that.
Yes.
In case of any alleged breach of any express or constructive trust created for public purposes of a charitable or religious nature, or where the direction of the court is deemed necessary for the administration of any trust, Advocate General or two or more persons having interest in the trust, having obtained the leave of the court, may institute a suit, whether contentious or not, in the principal court of the original jurisdiction or in any court empowered in that behalf by the state government within its local limits.
This according to you within the trust,
Within the trust.
not outside the trust.
No.
Now, is it the case that
No,
they
this is
all were,
approx.
all were not trustees or not connected with the trust?
Lords, this is an exercise where the trust gets dissolved. It supersedes the trust. Section 42, section 43 exercise supersedes the trust because of the deemed effect of section 44. So where is any question of going under section 92? Section 92 is having very, very limited scope, where there is some mismanagement within the affairs of the trust, removal of the trustee. All these things can be brought about. But here is a case where the legislation has specifically empowered the state government to exercise the powers to take over the management itself from the trust. So dehors the trust and its management. This is a power which is vested where the government exercises expropriatory powers and takes over the management of the temple for public good. But section 92, now your lordships may kindly see, not that ink page 50 minutes of the writ appeal papers.
Yes.
Paragraph number 15 to 24 are the grounds. Not a whisper. Learned single judge at any rate could not have traversed beyond the pleadings.
No, you said page 50.
In page 50 minutes is the grounds in the writ petition. No inquiry conducted under 46 minutes.
No, there was a conductor.
154.
But the deputy commissioner is conducted, no?
No, deputy commissioner is the designated authority to submit the report. It refers to the commissioner. The district commissioner is the deputy commissioner. So
no, he's based on his report only. Everything has been done.
Yes. Lords, this is such a foolproof system where there is a two-tier inquiry. First, the deputy commissioner conducts an inquiry. At that stage, also they are entitled to participate. Then inquiry report is submitted to the commissioner, to the state.
Who can participate? Everyone.
Lords, it is free for all. It's free for all. Any interested person is entitled to come and participate in these proceedings. Then after that, then the matter comes to the state. State again holds further proceedings on the basis of this inquiry report. Gives a cause notice to those persons whose management is required to be removed and it is required to be taken over. So then the learned single judge records a finding, procedure is followed. There is nothing wrong with the procedure having been followed. So section 43 is complied with. Not because certiorari jurisdiction, not the classical requirement of exercise of certiorari jurisdiction is not on the decision itself, but it's on the decision-making process. Single judge, when he records that decision-making process is proper, then it should have been an extremity that the decision itself could have been ventured in. Even if the court finds that on the face of it, there is no subjective satisfaction as required under section 42. Notice the exercise of jurisdiction could not have been ousted. The single judge's order renders 42 and 43 redundant. There is no question of preventing the exercise of these powers by the state.
Yes.
So therefore, my lords, now may I just take your lords, what is the nature of stand which they are taking? Lords, as a matter of fact, I am told it is not even the 18 versus 1. It is 19 or so, 19 communities against these 15 people. That is how it is standing as on today. Lords, is my kindly see annexure G. This is one of the objections filed. Lords, by the what they call it as Uru Kateshwari Ammanavara Temple Board registered. There is no such recognition, my lords, under the scheme of our laws where they can. But to regulate themselves internally, to regulate themselves, they can register themselves as a society or a trust in whatever manner.
Yes.
Now in this, your lords will find the tone and tenor with which they say.
Yes.
Lords, at page number 154.
Yes.
Para 23. Sri Uru Kateshwari Ammanavara temple does not have any immobile property. Some individuals have donated land to build a Dasava Bhavan due to the lack of original documents in the name of temple. It has not been registered in the temple for technical reasons. Uru Kateshwari Ammanavara temple does not have any other assets besides the donations and offerings given by the devotees in the hundi. Therefore, the temple does not have any other source of income. Note, this is purely managed out of the public funds, the funds which will be contributed by the devotees. And then page number 156, para 29. This is where the problem arises. The Lingayat community has been managing the Uru Kateshwari Ammanavaru temple in Ummattur village for many years without any misuse or providing services to devotees efficiently. They should grow up, lords. They will have to come with others. They can't still claim exclusivity of management.
What does it say?
The Lingayat community, that out of 19, one community has been managing the Uru Kateshwari Ammanavaru temple in Ummattur village for many years without any misuse or providing services to devotees efficiently. There is no such exclusivity. It's a temple managed out of the funds which is contributed by every single person. From a rupee to 1,000, lords, there are contributions which are coming to this temple, and that's how. It is the devotion which holds the temple and not the contributions. And they cannot say that a community is handling the affairs. This is the tenor with which they file it. Lords, now the temple administration is concerned is an inclusive process. There is no question of excluding any community. Every Hindu is a Hindu for the purpose of this act, whoever is a Hindu. And you cannot exclude. And this is the manner in which, lords, they took an objection before the Deputy Commissioner. And the Deputy Commissioner report was like that. Also, the Additional Advocate General has read the report of the Deputy Commissioner. I will not be repetitive. So therefore, my lords, in exercise of a certiorari jurisdiction to the least, this is not something which was called upon for the learned single judge to have done. But just at the cost of repetition, may I just take your lordship to the orders of the learned single judge. Para 17, my lords, in particular. Yes, para 13 I will read and then go to para. I'm sorry, my lords, I'm repetitive so that I just get a connectivity, my lords, while arguing. Para 13 at page number 23. Respondent number 2 has issued show cause notice at annexure of page Annexure F, section 43(1) the Act. Petitions have preferred objections and written submissions, annexure G and G1. Respondent number 3 has authorized officer to conduct inquiry to the objections in complaints of 46(3) of the Act at annexure H. Respondent number 3 has submitted a report on 59(21). Annexure B. Respondent number 2 in terms of 43(7) of the Act has submitted a report to the government recommending declaration of petitioner number 1 as declared institution under section 40 of the Act. Respondent number 1 acting on the recommendation of respondent number 2 has declared the petitioner as declared institution under 42 of the Act. In view of the above, the procedure contemplated under section 43 of the Act has been followed. The circumstances of the contention of the petitioner that procedure under section 43 of the Act has not been followed cannot be accepted and the same is rejected. Section 42 of the Act mandates the state government to declare an institution under chapter 8 of the Act on being satisfied with the report of the commission under section 43 of the Act. As seen from the impugned order at annexure A, respondent number 1 except reiterating the conclusion arrived at by the inquiry officer, that is respondent number 3, and except making a reference to the extent that recommendations of the commissioner has been thoroughly examined, no satisfaction has been recorded on the report of the commissioner submitted under section 43 of the Act to declare the institution under chapter 8 of the Act. This is the only reason, if I may say so with utmost respect. On the basis of the report of respondent number 3 and the recommendation of respondent number 2, respondent number 1 has recorded satisfaction to arrive at a conclusion for the purpose of section 42 of the Act. Mere reference to inquiry report of respondent number 3 and respondent number 2 are concluding under section 42 of the Act is only on the borrowed opinion. The order declaring institution under chapter 8 by respondent is without recording satisfaction under section 40 of the Act, without application of mind. For the aforesaid reasons, the impugned order at annexure A cannot be sustained. But still here, absolutely no difficulty. Even if the learned single judge felt that the reasons are not this is not factually also it is not correct, because the nature of satisfaction which is required in terms of section 43 is objective satisfaction. Is what the learned single judge says has understood and said that this is how it should be recorded. If the findings were there and the findings were not seriously disputable before the state government, the state government saying that I'm accepting whatever reasons are forthcoming in the inquiry report in the absence of any contrary materials and I pass an order in these terms could not have been faulted. But nonetheless, but where the problem starts, it's paragraph number 16. The entire dispute is arising due to the complaint lodged by response 5 to 13 with reference to mismanagement of the temple trust. Trust at annexure J depicts it's a public charitable trust having objects of public charitable activities at large. Total number of trustees declared is 15 in number. If respondent number 5 to 13 have any dispute against the trust, section 92 of the Act provides for the aggrieved person to institute a suit before the principal court and original jurisdiction within the local jurisdiction of within which the trust is. This is where we find the problem. The question of the statutory power under 42 being shunted out because there can be a possible remedy under section 92 minutes is completely absurd. Of course, I don't want to be repetitive, but only to say that to enter into the mismanagement of the affairs of the trust where the trust itself is in existence and the trust's affairs are regulated by either a scheme or by intervention of the court orders is a different aspect from the trust itself losing its significance over the management of the temple and the state taking over the management of the temple. Completely two different aspects. So therefore, the learned single judge misled himself. At the most, the learned single judge could have given one more opportunity for the state, saying that you give one more notice to them, record reasons and pass suitable orders. That's essentially what usually would have been done in any normal case. So, but this is a little far-fetched where the court has gone. So therefore, my respectful submission is that the orders of the learned single judge requires interference at your lordship's sense, and I'm grateful for the hearing.
Yes.
Yeah. Oh, yeah. That's 17. I'm sorry, Minister. That's para 17. The findings recorded by the third respondent, disputes have arisen after trust coming into existence in the year 2014 is without any basis. It is not open to respondent number 3 to record any finding on the correctness of the manner in which the trust is created, its composition and activities when the same is registered, and the remedy is to redress. This is not. This is a centuries old temple. Trust comes into existence in 2014. The report also says that for the first time in 2014, after several years, if some trust comes into existence and they want to usurp over the management of the temple, it would not be permissible. Is the nature of the considerations before the deputy commissioner. Notes to say that the trust coming into existence in 2014, it is not open to respond number 3 to record a finding on the correctness in the manner in which the trust is created, composition activities. This is essentially what is required to be looked into for the purpose of commenting on the mismanagement. First of all, we will have to see whether they have the powers to manage. There are several temples, notes, where the declared institutions has been undertaken where it is under the management of a private.
Otherwise, the old temples.
These are all old temples.
Before the,
Yes.
the earlier act,
Yes.
where notified temples.
Yes. These are all very ancient temples.
Very
And the following for this temple, the devotees following for this temple is enormous. And jatras
been
and all I
told
was
in-
told, but there were about 3 to 4 lakh people assembled in jatra.
All
4
the
lakh people.
entire Tamil Nadu and other places, Kerala also people will come.
But we have been told this is open only on Tuesdays.
Tuesdays.
Tuesdays of every month.
Not all days,
No, Tuesdays of every month.
only
Only
Tuesdays.
Tuesdays. Very powerful deity, notes.
Some temples, my lords, in Tamil Nadu and Karnataka, they, especially goddess, my lords, either on
come
Fridays
here.
or Tuesdays, my lords.
As a matter of fact, there is one temple, notes, in the foothills of this Baba Budangiri. That temple opens only once in a year.
Hasanamba.
Hasnamba again opens once in a year. There are some temples of the deities which opens only once in a year.
Once in a.
Is it?
That,
There's a-
ಏನದು?
Hasanamba.
Baba Budangiri foothills ಅಲ್ಲಿ ಇದೆಯಲ್ಲ? ದತ್ತಾತ್ರೇಯ. ಅದೇನೋ ಅಮ್ನೋರ್ ದೇವಸ್ಥಾನ ಅಲ್ಲಿ ಕೆಳಗಡೆ ಇದೆಯಲ್ಲ. Devi Rama. There's a hill.
The reason is only this possible, Mr. Ravi Shankar. Only one day everyone wants to have a darshan.
Yes.
That's possibly that's the reason. No, we were saying that this is not a notified, though despite a
No, it is not notified temple under the erstwhile enactments.
nothing.
But this is the problem. Wherever there were notifications, there were litigations, so on and so forth. But wherever notifications were not there, they were not notified institutions under the present enactment. But it does not mean that the government should lose control of those temples where there is public money coming in, public devotees are there. These are all public temples. Government cannot lose, my lords, control over all these temples.
But then, see, either it would be a notified or it would be
Declared.
42, 43.
That's all.
That's all.
That's all.
So not being notified means the people can run the
Yes,
temple
they will.
management.
Yes,
If in eventuality something arises, then 42, 43 is there.
43 will be excised. But there is an objective, my lords, because the single judge to say that, all right, 42 order may be defective, but you take recourse to section 92, my lords, is absolutely absurd. Where is any question of, my lords, section 92 debarring the exercise of statutory powers under 42, 43, 40? The end of finished matter.
Yes.
May I please your lordship?
May I seek your lordship's excuse? Great.
My lord, to begin with, it's my respectful submission for on behalf of different respondents 1 and 2 that the government state has no locus standi to file the appeal. My lord, in what way? State is in.
May I
One
take my
sec-
lord's leave and come? Great.
But who is there for you?
My government
Yeah,
advocate.
because he is challenging your locus to file an appeal.
I'll just be there.
Yes.
My lord, it's
I'll-
a state. It's a state. What interest, my lord, other than 42? If 42 is satisfied, then the state comes in, question of state coming in, and managing the temple would arise. Otherwise, what is the interest of the state to file this appeal? The representation by few members of that village that there is mismanagement, therefore let it be declared. That was the simple representation on which the Honorable Division Bench ordered notice, directed the authorities to take action. The authority, that Deputy Commissioner, has conducted the inquiry, my lord, I need to say, and that 43 has been followed as held by the learned single judge. There is no defect in the inquiry. Now, if that is so, why the state, what is the interest of the state to file this appeal? What is its interest in that?
Challenge the state action.
Yes, I am challenging the state action in filing the appeal because they are the person to decide on a particular issue, and they pass an order, a GO is issued. That ends the matter. Why it is that they have filed the appeal is for the reason, my lord, there is in this learned single judge's order, he has directed the Tahsildar to hand over the key to the petitioner. And such an order was passed earlier also. My lord, at annexure E1, would your lordship kind enough to see page 112, annexure E1, that is dated 28/4/2016.
Yes.
Yes. That the learned single judge has passed an order to, this is what, pending consideration of the petition, the second respondent is directed to open the door of the temple and permit darshan of the deity to the devotees on the first Tuesday of every month. The second respondent, for the said purpose, if necessary, may arrange for sufficient security in the area and thereafter close the temple door after the darshan for the day is completed. My lord, this was as back, it was on 28/4/2016. From that day onwards, the temple door was open on all the Tuesdays of the first Tuesday of the month. Now, when the learned single judge passed the order and we reported it to the Tahsildar, Deputy Commissioner, the Deputy Commissioner issued a letter to the Tahsildar. Please obey the, directed that obey the court order.
Interim order.
Yes. Not this interim order, final order, this round of litigation.
Okay.
Tahsildar was not in a mood to open the door, not ready to hand over the key. That interest of the particular officer has resulted in this writ petition. Otherwise, my respectful submission is they have no locus standi to file the appeal.
Yes.
My lord, the next submission of mine would be under section 42, my lord, of the Act. 42 says that whether or not governed by a settled scheme is being mismanaged, kindly see this, only one word, is being mismanaged, then declare such institution to be subject to the regulation of this chapter. So, if the institution is mismanaged, then take that into your fold. Chapter the other sections of this chapter will follow. How do you come to a conclusion that it is being mismanaged? That is provided under 43. My lord, the 43, there is no defect. I made my submission clear earlier. Now, what is to be seen is whether by the report of the Deputy Commissioner, has he reported mismanagement? My lord, whole thing centers around mismanagement. The report of the Deputy Commissioner, if gives a conclusion that there is a mismanagement, then follows 42. The government can issue a GO. My lord, in that background, would your lordship kindly permit me to read the report of the Deputy Commissioner, whether he has reported mismanagement. That starts at page 57, report. The English translation at page 65. My lord, in passing, I may bring it to the notice of the court that the Deputy Commissioner has recorded that this temple is managed by a particular community, and it is in management since 1940, definitely on record, because there was a suit in OS 648 or 4445 for declaration that the other community has the right to manage. That suit came to be dismissed on 18/6/1946. That is referred to in page 73. OS 648 of 4445 came to be dismissed on 18/6/46. Paragraph 4 in page 73. Then RA 20 came to be dismissed on 8/6/1949. RSA 194/1949-50 also came to be dismissed. And it was recorded in all these proceedings that a particular community is managing the affairs of the temple. Then comes another suit, second round of litigation in OS 664 of 52-53. That suit also came to be dismissed. My lord, after that, in the year 2014, the trust was formed. The present trust, respondent number 1 was formed. That was also challenged by certain members by filing section 92 petition. My lord, section 92 petition came to be dismissed, against which they filed MFA 1827 of 1827. That came to be dismissed by Annexure D, page 93, my lord. Page 93. On 6/1/2020. It was dismissed as withdrawn. My lord, I need to say that in that proceedings, the respondents herein, they make an application to get themselves implemented in the trial court. That application came to be dismissed. I have stated all this in the synopsis. So My lord, I was referring to the fact of mismanagement, whether it is recorded by the Deputy Commissioner. Kindly see, the case analysis is at page 74. At page 75, paragraph 2. The opposite party had submitted, that is myself, my lord, submitted the judgment copy of the order passed by the lower court with respect to the ownership so-and-so in charge of Urkateshwari temple from the copy of the judgment passed in OS number so-and-so, RA number so-and-so and OS 644 so-and-so. It is evident that in all three cases mentioned above, the temple belongs to Lingayat community of Ummattur village. And from there, after till now, the period, no dispute has arisen in regard to the ownership and maintenance of the temple. My lord, there is no dispute at all. Then it is to be noted that in the year 2014, when a trust was formed by some people, therefore for the maintenance of the temple, and a result of communal violence and misunderstanding took place, and even various suits were filed. As a result, this was disturbing the peace in the society over there. Furthermore, it is to be noted that during the period from 53 to 2014, Lingayat community did not have any claim with regard to the ownership of the temple. And that during that period, the people from all the communities there would conduct the festival of the village deity together. My lord, all the villagers, they come together and they conduct the festival, even the worship on every Tuesday. And my lord, kindly come to paragraph 6. This may be. From the records, it is observed that the members of the trust have failed to gain the confidence of the people belonging to the Lingayat community and other community of the village, and many complaints have been received from the people that the trust is not taking care of the management, temple management effectively, and prima facie it is clearly visible. The legal points, my lord, may kindly see this, legal points and opinion of the public with regard to the traditions and customs and other rituals followed therein by the so has been thoroughly considered. When deciding the factor related to the case of religious institution, it appears very important that not just the legal points must be considered, but it is very important that even the opinion of the people with regard to traditions, customs, and other rituals followed therein be considered. It is to be carefully noted that with regard to the point that when the car procession of Urkateshwari Amma temple takes place, the 19 different communities living in the village devotedly offer their service. All the 19 communities. This fact itself is enough to show the religious peace and harmony that exists. This is the report of the Deputy Commissioner. Therefore, from all these facts stated, the report is hereby submitted that with the recommendation that Shri Urkateshwari Amma temple must be notified body. Now, my lord, the report is that there is communal harmony, there is no other mismanagement, financial mismanagement is not spoken of. There is no report on that.
Yes.
There is no such report. Therefore, to include it under section 42, it is my respectful submission that that should be a report of mismanagement. There is no report of mismanagement. My lord, then coming to the GO, declaring it as this declared institution, GO does not say anything about this, just a repetition of the report of the Deputy Commissioner. Whatever Deputy Commissioner has stated, it is a repetition and it is declared as an institution under 42. Therefore, my respectful submission is 43 is followed. But the 42 core aspect is that should be mismanagement. In the entire report of the Deputy Commissioner, there is no whisper of mismanagement. Now, coming back to my learned friend on the other side, senior counsel is saying that God is one for everyone. Yes, these people also, respondents 1 and 2, they never prohibited anybody from worshipping the God. Everyone comes there. they participate, they give their offering, and it is done. Nothing else. On the festival day, all the 19 communities, it is the report. 19 communities come together and participate in the function. As far as management, that is by the trust. And none of the trustees have so far come before the courts and have said that it is mismanaged. Then my learned friend, Mr. Ravi Shankar, also.
You are the trustee.
We are all trustee. First petitioner, first respondent is the trust. Second petitioner is the president of the trust. And everything is going on smoothly. And totally there are 15 members in the trust. And per month, the expenditure comes to about 10,000. The Tatekasu is the only income of the Pujari mill. Other than Tatekasu, he does not get any emoluments. And it is going on for a number of years. At least as per record from 1940, this is going on. It's a 300-year-old institution. Therefore, much credence cannot be given to say that there is mismanagement. Of course, my learned senior counsel also said there is no financial mismanagement. Financial mismanagement is not the only. Therefore, they also admit that there is no financial mismanagement. What other mismanagement? No instances have been cited. All that is done is as per the custom. This temple is opened on Tuesdays. The puja is going on. And there are always a disgruntled person in every section of the society. They make a representation. When the representation was not considered by the government, they approached this honorable court by a public interest litigation. There was a direction mandamus to the government to hold an inquiry. Inquiry is held. And the inquiry report is that doesn't show any mismanagement. That is all, my lord. That's all. And the court may also consider this temple doors are closed since the order of the learned single judge. Till then, all these years, 6, 7 years, as per the court order, it was open. Now only after this order was passed, because of this particular.
What was the previous order?
Previous order, I brought it to the notice of the court. So that is annexure E. Yes, madam. Annexure E1. Annexure E. That was the order. That was also first it is an interim order itself. Court directed that the temple door should be open. My lord, my learned senior counsel made a statement on section 92. It was not at all required. It was, because otherwise than section 92, they went on saying that it's mismanagement. Then they say that they are not the trustees. In the light of that, it was very much required for the learned single judge to say that if you have any grievance, the doors are open through section 92 CPC. This is not the fashion. What is wrong in that, my lord? I don't find that the learned single judge's order calls for any interference. Okay. That's my respectful submission. And legal submission, only 2.5 pages. I've placed it before the court. Already placed before.
My lord, one more thing I would like to clarify, that is the petitioner in the writ appeal 154 of Jaishankar, he belongs to a Lingayat community. Other than him, another 5 members, the petitioner is also belong to that community, my lord. So that one thing I have told. What? The petitioner Jaishankar in writ appeal. In writ appeal 154.
The other writ petition, the other writ appeal.
Connected. It has club with petition. In writ appeal 154 of 24, the petitioner, Mr. Jaishankar, he is belong to a Lingayat community. Other than, I don't know another 5 members name, exactly what. Another 5 members also belong to a Lingayat community. So that thing I want to clarify this.
My lord,
We'll reserve it.
yes, before parting with this, my lord, kindly see page 182, my lord. Sorry for, in writ appeal 154, my lord. Volume 1. My lord, at page 182, paragraph 7, this is the statement, written statement filed by
Which page?
page 182, my lord. In WA 154, my lord.
That's right.
Yes,
182.
182, my lord.
Which paragraph?
Paragraph 7.
Hmm.
The said, it is our statement. Said Urkateshwari temple belongs to Lingayat community. The management, administration and puja rituals and other temple duties belongs to only Lingayat community. No other community do not have any kind of rights, obligation over the said temple. It is allowed all the community to people and devotees to enter into the temple and take part in the puja and other religious program of the temple and engage in puja practices according to their religious practices. There is no restriction on them. We don't restrict. And it is also a matter of information that there are several Urkateshwari temple in the town by each of the community. And that I have stated in the next paragraph.
Okay.
Please, madam, I am obliged.
We'll reserve it.
Please.
Thank you.
Only one point, my lords, the taking over by these 15 people claiming to be the representatives of a particular community is itself wrong, because that is also the observation in the report. They do not represent the community, these 15 people.
Thank you.
Great.
Yes.